Good morning, everybody. Happy Tuesday. Welcome to the Courtroom Files Live. Let's start our day with Judge Dad up in Michigan.
Files. Ma'am, you cannot leave the state without the consent of the court. You cannot violate any law or ordinance. You must appear in court as directed. You're not to enter the property address at 26414. 26414 Blue Heron Drive in Flat Rock. And no contact. Who's Alonda Beatrice?
Her sister.
And you're telling me your client is the appointed
Guardian and servitor over the father. I don't want to burden the court with the facts of the case, but there's a probate court follow-up hearing coming up in February, but I would like the prosecutor to look at all the facts and the court orders of who has the right to administer medical treatment to the father.
I got it.
So, and this would be a nice holiday story that could be wrapped up with everyone singing Merry Christmas, but I don't think that's going to happen, Your Honor. But otherwise, if you want to set it for the Tuesday before Christmas or after the first of the year, perhaps let things settle in.
All right. Let me just do this. I am going to order. So, ma'am, no contact with Alondra Beatrice. No contact with prosecution witnesses except through your lawyer. You're not to enter 26414 Blue Heron Drive in Flat Rock. You cannot leave the state. Cannot violate a law. You must appear in court as directed. I'm going to have to order her to go over to get fingerprinted by 1 p.m. today, okay, on both of these cases.
I'll explain that to her, yes.
And we'll give her the order and the bond sheet. Lisa, I've filled out two different orders for prints, but only one bond sheet. So we'll give you the date. When did you want?
Well, Madam Prosecutor suggested after the first of the year, but whatever works with the court, we're fine with it, Judge.
Lisa, what do you have for me, Lisa?
January 6th at 1 o'clock.
January 6th at 1 o'clock.
Yeah, I'm going to be handling this. This is going to be Judge Hessen's case, but I'm going to be handling that docket that day. I don't know if she's told you, Lisa, but I'm going to handle that docket. But I have an appointment and I won't be in until 10:15. So that's what we'll do. 1 p.m. on that date. You can go down the hall, get your notice, personal bond. You're all set. Wish you well. Good luck.
Do you have any trips playing out of town before the first of the year? We'll notify.
We should all leave town with all the snow.
Look outside, Judge. You'll wish it had been yesterday.
I know. Thanks. Good luck.
Thank you.
Okay. Good. Okay. So this is people against. All right. Hang on 1 second. I'm getting all that. There we go. All right. Rodney Sean Tuttle. And I want Officer McParlin here, 25B701-485. Good morning, officer. I'm gonna ask you to take your hat off. Tell me your name, please.
Yes, Your Honor. Excuse my air. I'm Officer Gage McParlin with the Brownstown Township Police Department.
Names again over here.
John Freeman on behalf of Mr. Tuttle.
Name.
Ron Sean Tuttle.
All right. So one of the things I pointed out, he pled to attempt, resist, and obstruct, 2 counts, a 1 year. And then he pled also to use of methamphetamines, which is a 1 year. And I pointed out, I read in the report where you said he punched you in the forehead. And his lawyer's saying it's on video and he's inviting me to see the video, and I'll be happy to look at the video. But he's seemingly disputing that. He's saying that you tackled him, right, Mr. Freeman? I don't want to put words in your mouth.
So, Your Honor, I just rewatched the video. So my client is given a lawful command to stop. The officers wanted to speak to him. He refused to do that, and he started to move away from the officers. So I believe it was this officer that's currently on the video attempts to tackle my client. he is the person that initiates the physical contact. My client begins to run, and during the course of trying to run away, this officer loses his footing and falls to the ground. There's a second officer who is involved in the pursuit. This is all visible to me, at least, on the body-worn camera footage of the second officer, who's a little bit farther behind. I do not see anything on this video of my client attempting to strike.
He didn't say attempting. His report says he struck him in the forehead. That's what it says.
And
He said, as I reached out to grab Tuttle's wrist, he pulled away from me. I reached again for his arm. Tuttle punched me on the right side of my forehead. I lost my balance and fell down to the ground, and Tuttle took off running northbound on Kirby. And then he talks about how he and Officer Grimm tackled Tuttle to the ground on the cement driveway. While Tuttle was on the ground, he continued to fight with me, resisting arrest. Grimm and Novak, fighting with me, Grimm, and Novak. I personally had to knee Tuttle in the ribs to get him to surrender his hands. I also attempted to strike Tuttle on the shoulder, but he moved and I struck his face. After 2 minutes of fighting / resisting, we were able to handcuff him and place him in an upright position so he could breathe. So I'm just asking you, because I'm going to look at this video.
Yeah.
Did he in fact punch you in the forehead?
Your Honor, I remember being struck as I went to grab Mr. Tuttle, and at that point I fell. That's what I remember. If the video shows anything different, that is just, I would like to see it as well, but that's exactly what I remember, and my video camera fell off. But that is exactly what I remember.
Can I see the video?
of course,
All right, you want to pull it up here?
give it up.
Can we, he's got it on his podium here, at the podium, Lisa. Can we, tech savvy, I'm not. Can I get it up on the screen there, or?
I'd also be happy to step up and try to facilitate the court. Watching it on my laptop, there is some audio to it.
Yeah.
If he wants to join the Zoom, he can do a share screen, or he can send it to me and I'll share screen.
Friends joining the Zoom.
Okay, let's have you do that. I'm sorry to call you on such short notice, officer, so just bear with us if you will, please.
Not a problem, Your Honor. I don't want to be wrong in this case, so please, yes, pull it up, and thank you for calling me.
No problem. I hate to do this, but while you're doing that, I'm going to go on to another case here, okay? Mark Charles Matthews.
Good morning once again, everybody. Happy Tuesday. Welcome to the Courtroom Files Live. I think we'll stick with Judge Dad for a while because it looks like they're going to pull up some video. So that could be fun. Looks like we've stumbled into something kind of interesting already this morning. But I hope everybody's doing well. Let's have a good day today.
Matthews, your name? Mr. Matthews?
I'm sorry, I was muted, Your Honor. Good morning.
Your name?
Mark Matthews.
Okay, just stop walking for 1 second. I'll get you out of here. The officer didn't show up. I'm sorry it took us so long to get to you. I had something come up this morning. Case dismissed. You're all set. Have a nice holiday.
Thank you, Your Honor. I appreciate it.
Carson Matthew Morrow, 25M615488. Have a good one, Mr. Matthews. Trooper McLaughlin.
You as well.
out to you. Carson Matthew.
Hello, Your
Okay,
Honor.
I'm going to ask you to take your hat off, Mr. Morrow. And tell me your name, please, Mr. Morrow.
Carson Matthew Morrow.
And Trooper McLaughlin, your name, sir.
Yep. Good morning, Your Honor. Daniel McLaughlin.
Good morning to you. Okay, so he's got a clean record. You got him going 91. You wrote him for 85 and a 70 limited access. Any offer here?
Yeah, I can do 1 to 5 limited access if you'd be willing to accept that.
So Mr. Morrow, he's offering you to plead to 75 and a 70. If you do that, it's 0 points, but it will go on your record. You understand that?
Yes, Your Honor.
Do you want to plead to that, or do you want to have a hearing on the 85 and a 70?
I would like to plead to the 75 and a 70.
All right, to the charge limited access, 75 and a 70, responsible or not responsible? You plead responsible to 75 and a 70?
Yes, Your Honor.
I'll accept the plea. 150 is your total. You can pay that today, can you?
Yes, yes, I can, Your Honor.
33court.com, okay?
Awesome. Thank you, Your Honor.
Have a great Christmas. Do you have
Yes,
any more, Trooper? I don't
I don't
think
believe
so.
so. I don't believe so. I think it was just Mr. Morrow.
All right, well, have a great Christmas if I don't see you, sir. Thank you, both of you.
Yes, sir. You as well.
Yes.
I'll see you. I'll see you on the 15th.
Okay, all right.
All right. Take care.
Thank you.
You guys have a
Thamer,
good Christmas, Your Honor.
thank you.
Have a good
Thamer
one.
Matham Al Yawi, 25M 604-474 A, B, and C. Prohibited holding. I don't know what that means. Counsel, your appearance, good morning to you. How are you?
Good morning, Your Honor. I'm standing in for the attorney record, Mr. Samir Jadallah and Larry.
Oh, no, I don't have yours. I'm sorry.
Okay.
That isn't the one I called. Counsel, your appearance.
Good morning, Your Honor. Attorney Amir Al-Khalidi on behalf of Tamer Al-Alyawi.
I want to make sure I'm reading this right. It looks like I'm dismissing the expired plate and the no proof of insurance. And then the defendant's going to plead to impeding. And I don't know what she means by prohibited holding. Is that operating a text?
Yes, it is.
text? So your client's going to plead as charged as to count 3, operating while texting, right?
Correct.
And then where am I putting the impeding? I don't think it really matters, but
We're
I'll
just
have it-
count 1, 2, replacing it with, count 1 could be impeding.
right. So count 1, he'll plead to impeding. Count 3, he'll plead as charged. And original charge on count 1, expired plate dismissed. And count 2, no proof of insurance is going to be dismissed. Am I reading that all right?
Yes, you are.
Okay. And you're authorized to enter this plea on behalf of your client, right?
I do, Your Honor, yes.
All right. As to count 1, impeding traffic, responsible or not responsible?
Responsible.
As to count 3, operating while texting, responsible or not responsible?
Responsible.
Okay, I'm accepting the plea to impeding on file 1, count 1. I'm accepting the plea to operating while texting, file C, count 3. All right. And then I'm going to just, I'm sorry, I'm accepting the plea to impeding on count 1, accepting the plea as charged on count 3, dismissing no proof of insurance count 2, and dismissing expired plate on count 1. I'm going to assess fines and costs on the C file of 210. Really, the expired plate is what they're putting for the impeding, so I'm only going to charge $100 on that. So your client owes 310. Can your client pay that today, or does he need time?
Can you do 14 days, Your Honor?
No problem. Yeah, pay by the 23rd of December. I'll just make it, okay?
Sounds good. I appreciate it, Judge. Thank you.
Have a great day. Thank you very much.
Bye-bye.
All right. Okay. Now we're going back. Give me 1 second. Now we're going back on Tuttle. All right, recalling Rodney Sean Tuttle, 25E701485. You and your client can sit right there, counsel. You don't have to stand at the podium. Come on over and sit next to your lawyer here, Mr. Tuttle. And Officer McParlin, I just want to make sure you can see this as well. You can see this?
Thank you, Your Honor. Yes, I can see it.
Okay, you can go ahead and start the video.
So, Your Honor, I'm not sure about the audio part, because there was some feedback, so I don't know if the courtroom has to be muted. I assume the court wants to hear the audio.
Yeah, let me see that. Let's, if we have a problem, I'll tell you to stop it, okay?
So, Your Honor, I can hear it here, but I can't, I don't know.
I'm here, I'm able to hear it a little bit.
Your Honor, is it lagging on your end?
It's not the best. Where's that coming from?
From my, his left hand.
I should have paid attention in typing class. Okay. I don't even know how to mute myself. I got, see, I mean, there's part of this that's weird. We got the audio already muted over here. Okay, try it now.
You're already muted.
All right, I'm just gonna watch it. Just let it go for now. Keep it going. Oh.
Yeah, we can. So just that, I talked to us, so we don't, we actually, it's totally so good. You're going to let that try. We have talked to you. Okay, what is it? Why did you get more time?
Your Honor, I think that the critical part is what we just watched.
Yeah, I want to go back. I want you to turn it back about 15 seconds. Can you see this okay, Officer McParlin?
Not at all, Your Honor.
Go ahead, play it.
Trying to get short time.
Yeah. All right. You can approach the podium and let's finish the sentence. Officer McParlin, you are the victim on this. You are welcome to tell me whatever you'd like to say.
Just one thing for clarification, Your Honor. Again, the video I can't really see very well, but I don't want to put or make any statement if I made it wrong or whatever. Did you see him strike me? I cannot see the video.
It looked to me like he did. At one point, when you went toward him, it looked like in the process of him trying to get away that he did take a swing, but I'm not positive about that.
All right, just because I don't want to be an officer known for any kind of like someone think I just falsified anything here, because if I'd set the record straight. But continue,
No.
Your Honor.
Nobody thinks that, okay?
All right. Yes, Your Honor. I appreciate that.
Do you want to say anything else?
Mr. Tuttle, if I could speak directly to him, if at all possible, Your Honor.
Sure.
Or to the court. Mr. Tuttle, despite what happened, sir, I really hope you get the help you need wherever you're going in life. All right, buddy. I know I know you were on Allen Park. You had an incident there. I wish the best for you and your family. Okay.
Appreciate it.
Not a problem, man. Good luck, brother.
Can I have 3 probation orders? Counsel, what else would you like to? You're free to sit there if you want still. I don't have any problem with that.
It feels awkward, Your Honor, for all of you.
I get it. I get it. I'm sorry. I didn't mean it was in that, the probation orders. I'm sorry. I'm not probation. Yeah, orders of probation.
So, Your Honor, since I first started interacting with my client back, months ago when I was hired on this matter, my sense is that he's been doing everything right. He was living in Florida after this event, and he went through a rehab program there. He was working gainfully employed with Amazon. And he just seems to be on the right track. And I'm really concerned that ultimately, if he has to do the incarceration, that it's going to derail the progress that he's made. So I'm going to ask the court to follow the recommendation. My client has relocated to the state of Kentucky where he's got stability and living better.
So he's actually living in Kentucky now.
Yes, Your Honor. He started out in Florida. We came back here. You may recall there was an issue about him needing to have his fingerprints taken.
Yes.
I did all that. He's been here for the 2 in-person court appearances. So now he's residing in Kentucky with his dad where he's working. We have no objection to the recommendation. I think it's very fair. I think that addressing what's going on underlying with Mr. Tuttle's behavior is going to be the key to success. And hopefully he never has to appear before a judge like this again. He recognizes that he's got to do a lot of work in order to make sure that that happens. And I would just ask the court to follow the recommendation, give him the opportunity. Your Honor, the court also, the last time we were here, directed him to appear or to attend AA meeting.
Yeah, because he wasn't doing it, right?
That's correct. And I do have, he's got a sheet here that's been signed that shows consistent meeting attendance between November 15th and December 7th. So I can provide that to the court.
No, I trust you, counsel. I believe you.
Your Honor, I think the video speaks for itself. I think the court has a clear grasp as to the facts of the case. And I'd ask them to show some mercy to my client.
Mr. Tuttle, anything you'd like to say, sir?
I just apologize for the situation. But the best is on board on both parties.
I'm sorry?
I hope for the best on both parties.
Are you going to be in Brownstown area at all?
Here, why I was thinking my father.
All right, 18 months probation. You cannot leave the state without the consent of the court or violate a law. You change your address, place of employment, or home telephone number, you must notify probation. You have to report as direct. No alcohol, no drugs. Stay away from that meth. No alcohol, no drugs, of any kind, not marijuana, anything. No alcohol, no illegal controlled substances, no marijuana. You can leave the state to go to Kentucky. You're not to purchase, possess, or consume alcohol or drugs. You're submit to chemical testing, PBTs and ETGs as follows. I'm gonna make it weekly for 2 months. If you're clean, I'll make it bi-weekly for 2 months. If you're clean, I'll then revert it to monthly. Okay? Kratom poppy seeds and CBD oils are prohibited. Consuming food or other items containing those substances will be deemed a violation. Again, you're to attend AA 3 times a week until I think he needs intensive outpatient treatment counsel. I really do. He's got too much of a history here. So 3 times a week until an IOP. Once you get into intensive outpatient treatment, you no longer have to attend AA or NA. Okay, do you understand all of this so far?
I don't understand what intensive outpatient is.
All right, well, it's more than once a week. They're gonna be having you go 3-4 times a week. Okay, and probation will explain that, and your lawyer will explain that. I think he has 1 day credit coming from the arrest. Is that true, or does he have more than that?
I think it's just one.
Okay. All right. I would make him do the court work program, but I'm not going to since he lives in Kentucky. 10 days jail, credit 1, serve 9. I'll let you serve 9 days of community service. That has to be completed by February the 20th of 26. In terms of fines and costs, and on count 1, I'm going to attribute everything. $100. What happened? $100 fines. 75 costs, $60 screening fee. That is $235. Probation fees are $360. That's $595. And then you have 75 and 50 for 75 victim choice fee, $50 justice assessment. So that's another $125 on top of the $595 for a total of $720. I believe on the other 2 counts, I'm just assessing 50 and just the justice assessment fees. So $100 fines, 75 costs, $50 justice assessment, 2.25 on both of those other files. Okay, so 100 fines, 75 costs, and $50 justice assessment. So that's 2.25 on those. I'm not going to charge you again, or 365 days. All of these terms and conditions are running concurrent. Do you understand that, Mr. Tuttle? All right. All right. So counsel, he owes $720 plus $450 or $1170. Can he pay all that today?
Your Honor, would the court consider a 2-month payment plan?
I don't have a problem with that. Okay, so let's just do this. Just give me 1 second. There's a lot of paperwork here. Oh, boy. Monthly, weekly. All right, so how do you want to be able to pay this, council? In other words, why don't we set up a payment plan and,
Would it be easier if the court just set a due date for?
yeah, I'd rather have them do that. I'd rather set up a weekly or bi-weekly or monthly or what have you. So how much can you pay weekly, sir, or bi-weekly? Can you pay $100 bi-weekly?
Yeah.
Well, let's just do that. $100 bi-weekly beginning December 23rd. And then you just pay every other week. If you don't have the money, call the court. We'll go on Zoom. I'll give you an extension. We're not going to have a problem. Just don't ignore me, okay? You'll meet with probation before you leave. Any questions?
Probation paying, just out of curiosity on how the.
You're going to talk to probation. They're going to have you test in Kentucky. You don't have to drive back to Michigan. And yeah, they'll answer all your questions. And if they don't, you can come back in here and ask me, okay? Anything else?
No, thank you.
Have a nice day. Take care. Enjoy your Christmas and everything. Thank you.
It's the Courtroom Files live on a Tuesday. Fun way to start the day. Got to see a movie, so that's always cool. Thank you, Ashley, for gifting 5 memberships. Appreciate that. Let's head over to Texas. We'll say good morning to Judge Stevens.
Plea on the harassment, dismissal, assault. Okay, so making sure it done. That was all talk about it. That's my stuff. You got it? Oh, it's not coming up right now. Trying to get the little thing is acting up. I know these computers be tripping, huh? It's all good.
We now call 25 CR 364, the state of Texas versus Jasmine Dudley. You are Miss Dudley?
Yes, sir.
Present with your attorney and the state's attorney. Mr. Adams, does the defendant waive a formal reading of the indictment and the arraignment here? Can we proceed in summary?
Yes, sir.
Okay.
Almost there.
One of the things that was done is there was an evaluation performed regarding competency of the defendant, and Dr. Edward Pond, licensed psychiatrist, evaluated the defendant and declared her to be competent.
I've printed it. I just hadn't gotten it yet.
It will, that report will be part of the record here and sealed.
Right like this. Your hand up above everything. Is that gonna? I just can't put my hand down. Put your hand down.
It's going to be interesting to know, but all right. Report is received and will be made a part of the record, and we will keep it sealed. On Dr. DuPont's report dated August 25th, 25, finding the defendant competent. In summary, 25 CR 364 alleges that on or about March 9th, 2025 in Jefferson County, Texas, you committed the 3rd-degree felony of harassment of a public servant, namely an employee of Baptist Hospital performing medical duties at Baptist Hospital. Do you understand what she is charged with? Do you understand what you were charged with? Okay. You're gonna, does she need to be sworn in?
Yes.
You need to go over here before we go any further? All right, this, ma'am, is a third-degree felony, which means you face, if convicted, no less than 2, no more than 10 years confinement in prison, and a fine up to $10,000 can be assessed. Do you understand?
Yes, sir.
And an agreement has been reached in your case where you would be pleading guilty placed on deferred or unadjudicated probation for 20 years. And other terms and conditions of probation, which are normal and customary for this type of offense. And furthermore, the other case, 25 CR 1453, would be dismissed as part of this agreement. Is that your understanding of the plan?
Yes, sir.
If I follow this, you have no right of appeal of your case. Do you understand?
Yes,
How do you plead to this, ma'am? Guilty or not guilty?
guilty.
Are you pleading guilty voluntarily? That is on your own free will, and because you are indeed guilty of what this alleges.
Yes.
I'll show you what's marked as State's Exhibit 1. Did you sign that document voluntarily? Understand it, discuss it with your attorney, or the contents all true and correct?
Yes, sir.
State's Exhibit 1 tendered into evidence.
No objection.
Without objection, it's submitted. Among other things, you are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. You are totally satisfied with the representation provided by your lawyer. You know what you've been charged with. The indictment's been read to you. You've read it. You were guilty of the crime charged in any lesser included offense. All of this is true, so help you God.
Yes, sir.
State's Exhibit 1 is part of the record for all purposes. Pre-sentence report is hereby waived. If nothing further, I'm going to find that you are pleading guilty today voluntarily. You are guilty of this crime.
Yes, sir.
You are mentally competent to enter your plea of guilty. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt. But I'm not going to find you guilty. I'm going to defer any finding of guilt so long as you follow these terms and conditions of probation, which are the regular type of probation terms. And most of these, there's 35 of them. There are a lot, but most of them are what I have to do. Have no contact with parties that are disreputable. Report as commit no offense. Don't associate with bad people. Report as directed. Work faithfully. Support your defendants. I mean, all of these things are good things. But anyway, follow them. If you fail, if your probation can be revoked, you can then be found guilty and sentenced up to the full range of punishment. In this case, it's a third-degree felony, so you were looking at no less than 2, no more than 10 years confinement in prison, and a fine up to $10,000. All right, here we go. I'm rendering these to the probation officer. See the probation office, and you can begin your probation. Okay?
Thank you, Honor. Appreciate it. We good.
See you later.
Yeah, thank you.
Yes.
All right, let's move from pleading guilty in Jefferson County and go to Florida. Wade Mercer.
Owens, you're here for first appearance. You've been accused of 5 new charges, Mr. Owens. You've also have an out-of-county warrant out of Gadsden County, and you have a warrant from the United States Marshal Service. So just be aware of that. Mr. Owens, in the Jackson County charges, you're accused of 1 count of trafficking methamphetamine, fleeing and eluding law enforcement officer, obstructing an officer without violence, felon possession of firearm, and a trafficking in synthetic cannabinoids or cannabinoids. And Mr. Owens, there's clearly probable cause on 4 of those charges. I'm not sure on the trafficking in the cannabinoids, but I'm not sure about that charge. I want to hear from the attorneys on that. Mr. McDaniel, anything you would like to say on that charge?
I don't think Ms. Jake is going to be objecting to that, are you, Jake?
Well, we are going to at least put an argument out there for the for that one. I mean, I reviewed the complaint and I know that there was issue or a question about whether there is a field test for synthetic cannabinoids. I can't even say it myself, but we would say that if you take into account the training and experience by the investigator involved in this and his years that he's had experience involved in these illegal narcotics, and the fact that the substances were found in proximity with a plethora of other substances, any reasonable prudent person would be able to find that, you know, this substance is a synthetic cannabinoid, and that's our probable cause argument for that.
Mr. McDaniel, anything?
Your Honor, I think it needs to be a test done. I mean,
I want it to be tested.
Okay, so Mr. Owens, they have to either test it or they have to show how they know or what leads them to believe that it is that substance. The entirety of any evidence that it is a synthetic cannabinoid is one sentence, and that one sentence says there were 5 clear bags of what investigator so-and-so advised was synthetic cannabinoids. There's nothing in there about what Mr. Mitchell's talking about that investigator's training experience classes, nothing. That is not sufficient. You can't just say John said it was cannabinoids, therefore that's enough for us. That's not sufficient for me. It's not sufficient under Florida law. So there's no probable cause for that charge. On the other charge, there is probable cause of trafficking methamphetamine because you've already won it in 2 other cases. Your bond's going to be $100,000. $10,000 on the fleeing and eluding, $5,000 on the obstruction without violence. The felon possession of firearm is a second-degree felony. You don't have a $25,000 bond. Mr. Mitchell, please notify the arresting officer. I'll go through those again. I know that was kind of quick, Mr. McDaniel. I'll go through those again. Just give us a second, Mr. Owens. I'm just probably going too fast. So the trafficking is 100. The fleeing and eluding is 10. The obstruction is 5. That's a misdemeanor. And then the felon possession of firearm is a second-degree felony. That's 25. So,
thank you,
Mr. Mitchell, please notify the officer that if he doesn't have, and some substances you don't have tests for, I get that. But if you don't, you've got to put something about the training and experience of the officer. You can't just say he's a narcotics investigator and that be sufficient for B. I don't think that's sufficient under the law.
We've been in touch with him this morning, so
thank you. So, Mr. Owens,
we would also request random UAs.
There will be a condition of random UAs if you're ever out on bond on these charges. Mr. Owens, they may amend that charge. They may amend the complaint and put that officer's training and experience in there. He very well may be training and have enough training and experience to identify the substance, but I can't assume that. It's got to be in the complaint. And I have no idea how long he's been a narcotics officer. I simply don't know. And if I did know, I wouldn't assume it. So they may or may not amend that charge. Right now, you don't have to post a bond on that case. So right now, your total bond is $140 cash or surety, but you've got two holds with no bond from other jurisdictions. Now, Mr. Owens, do you have any questions, sir?
When I was arrested, I was never gave a arrest report. So like, I'm trying to figure out what did I obstruct? What?
The allegation is that you ran from law enforcement. You got out of the car and ran, and you hid in the attic. That would, if that's true, that would by definition be obstructing justice. Any other questions?
I'll mute it again. I'm going to talk to you.
So, Mr. Jailer, I'm showing a child support warrant too. That's not something we'd first appear him on. But if y'all would check and see, it's not on our list. Y'all may be aware of it, and just it doesn't get put on the list, Corporal, because we don't first appear on. But I just want to make sure you're aware of. He does appear to have a child support warrant in 23-69. 23-69 is the case number. Thank you. January 6th. Corporal, we need to give Mr. Owens a notice for January 6th. That'd be his court date in felony court. 8:30. Wish you the best, Mr. Owens. Next case is Carl Richardson.
I believe no.
Mr. Richardson, good morning. Mr. Richardson, you have a hold out of Bay County. It looks like a violation of probation warrant where you've been accused down there of violating your probation. It's no bond warrant signed by Judge Register. Mr. Richardson, that means you're going to be held for Bay County. Today is Tuesday. Mr. Richardson, they may get you today. It also is possible they'll get you the next few working days, next several days. We asked the jail to bring people back if they're still here after 15 days. I don't think I've ever had that happen with Bay County. I just making you aware of it. There's a great likelihood you're going to be in Bay County this week. When you do get to Bay County, you'll go to a first appearance judge in front of a judge there, and they'll address your bond status. But right now you have no bond. And on the off chance you happen to be here in 15 days, I'm asking the jail to bring you back so I can see what's going on. That's very unlikely, but I want to make sure it's covered just in case. Do you have any questions?
My only question is, you said that there was no bond signed by Mr. Timothy Register, right?
Yes, sir.
Okay, that's my only question. Thank you.
Good luck to you.
Yes, sir. Have a good day.
You too.
We have Jeremy Martin next. Martin, good morning. Mr. Martin, you're here because you've been accused of violating terms of your county probation in 24-702 CT. Mr. Martin, I'm appointing the public defender's officer to represent you. I'm going to ask that you listen to Mr. McDaniel, sir.
Your Honor, I spoke to Mr. Martin. At this point, he's going to admit that he violated his probation. We're sending him to me since 90 days in jail. You have 4 days jail credit and whatever fine may be remaining. This will resolve this case today.
Thank you. Mr. Mitchell, is that agreeable with the state?
It is, Your Honor. How many days credit does he have?
Four.
Four credit. Mr. Goodson?
He has a fine balance of 858, Your Honor.
858. Mr. Martin, did you hear all that, sir?
Yes.
And is that the plea or admission you would like to enter, Mr. Martin?
Yes.
Mr. Martin, I'm going to accept your admission that you violated the terms of your probation in case 24-702 CT. I'm going to revoke that probation, Mr. Martin, sentence you to 90 days in jail, but you've got credit for 4 days you've already served. You do still owe court costs and fines of $858, but Mr. Martin, you'll get a chance to work those off at the jail through the trustee program. If you get in that program, it's also going to help you get some extra gain time off of your sentence. Mr. Martin, there's no probation left in this case. You finished this jail sentence, sir. This case is over with. Do you have any questions? No? All right. Wish you the best, Mr. Martin.
Thank you.
Yes, sir. We have Sabian Painter. Mr. Painter, good morning. Mr. Painter, it looks like you've already been sentenced to 10 days in jail for the charge of driving while license suspended, but that sentence only kicked in after you didn't show up for your court date to request an extension if you needed one. So normally what we do in these cases is what Mr. McDaniel is about to do in your case, I think. So listen to Mr. McDaniel and we'll see if everybody's on the same page or not. Mr. McDaniel.
Your Honor, we'd ask the court to amend the sentence to 10 days in the county jail. They have 1 day jail credit. However, he can be released from jail by paying the sum of $300 at the clerk of court. And once that payment is made, he'll be released.
Mr. Painter, hopefully you make the purge. If you don't, that jail credit becomes important. I saw something about getting picked up in Washington County. When did you get picked up over there?
Friday.
Okay, so
Well,
was there another
I didn't
charge
get
or
picked up.
just?
I actually, no, sir. So there was a buddy of mine. I just got back from Cheyenne, Wyoming, and a buddy of mine, his bikes went missing, his motorcycles, and they called me to ask me some questions since I was over there. And of course, you know, they excluded me from the case, but they said that there was a warrant out for my arrest and picked me up Friday and took me in and up and in.
I'm just trying to make sure you get the right credit. Mr. Painter, you were not arrested for anything else, correct?
No, sir. No, sir.
So I don't know that Mr. McDaniel was aware of that Washington County few days over there. So Mr. McDaniel, what do we show on total sentence then?
4 days jail credit. He's going to make the purge today, though, I believe, Your Honor. So it's
Great.
Be 4 days, so.
Yes, sir.
Great.
I want to
Mr.
pay
Mitchell.
whatever I need to pay and get going.
Okay, Mr. Mitchell, is that agreeable with the state?
That is agreeable with
And
the
Mr.
state.
Painter, is that what you want to do is to modify that sentence?
Yeah, yes, sir.
Okay, Mr. Painter, what I'm going to do is I'm going to grant the request to modify the sentence. I'm going to amend the sentence to, it's still 10 days in jail, but now it has a purge. You've got credit for 4 days towards that sentence. If you're not able to make the purge is the same amount you were ordered to pay previously. That purge amount is $300. Mr. Painter,
Okay.
you make that purge amount, you'll be released immediately. Mr. Painter, purge amounts are made at the clerk of court's office. Now that's important because they're open 8 a.m. to 4:30 p.m. So
Okay.
if you get friends or family to try to make that purge today at 5 o'clock, you're going to spend another night in jail because the clerk's office won't be open until tomorrow morning again. So make sure you tell friends or family it needs to be paid today before 4:30, preferably before 4 o'clock. So we make sure we have time to get the paperwork out there to get you out. Mr. Painter,
Yes, sir.
you'll get a chance to use the phone in a few minutes, sir, to make that purge. Do you have any questions?
No, sir.
All right, sir. Wish you the best. We have Robert Scott Jr. Mr. Scott, good morning. Mr. Scott, you're here because you've been accused of 2 charges. You've been accused of abuse of an elderly or disabled adult without great bodily harm. That's a second-degree felony. And then yesterday, you were accused of escaping from a sexually violent criminal facility is essentially the charge. And I think the officer, I know you look confused. I think the officers got you on charge on the wrong statute. So there's been some text back and forth this morning on that issue. I'm going to appoint the public defender's officer to represent you and ask that you listen to Mr. McDaniel first. Mr. McDaniel?
Yeah, Your Honor. I mean, I guess the, assume it was a mistake by the officer putting that in there. I mean, this escape would be just a regular escape from custody from him, I believe. So we just asked to take that into consideration and set the bond.
Okay, so looks like I missed a charge, and the jail did too. No, the jail didn't miss it. I missed it. So this because of the way the warrant is done, the warrant is very confusing. Yeah, there's a third charge of robbery from the old incident. So you actually have three charges: robbery, abuse of an elderly or disabled adult, and then the escape, which appears to be the wrong statute, at least on a cursory review. That's what it looked like. Mr. Mitchell, anything?
Yes, Your Honor. We'll be in contact with the officer to amend the complaint, but we just offer to treat it as an escape charge for today's purposes.
Any objection for bond purposes that I treat it as a regular escape and set a bond accordingly, Mr. McDaniel?
No, Your Honor, no objection.
Okay, so Mr. Scott, I'm going to set your bond as follows. I believe all of these are going to be second-degree felonies. So your bond's going to be $25,000 on each charge. Mr. Scott, your bond is $75,000 total, cash or surety. I'm going to ask Mr. Mitchell to notify the officer and the arresting agency of the two different escape charges. One is 944.40. That's regular escape. And this officer charged him under the Jimmy Rice, what's known as the Jimmy Rice statute, which is civil commitment of sexually violent predator statute. And he's not even accused of being that. So I think the officer just got the wrong escape statute.
I gotcha.
So Mr. Scott, you've got the right to post a bond, sir. You do have a condition of no contact with the alleged victim in the robbery and the alleged allegations of disabled adult abuse. It's the same person. You have no contact with that person, but you've got the right to post bond. Mr. Scott, you'll get a chance to use the phone to contact friends or family in just a few minutes. Do you have any questions, sir?
No, sir.
All right, sir. Wish you the best. We're also going to give you a notice for your court date. I'm going to ask the jail to do that January 6th at 8:30. Tyvon Leonard. Mr. Leonard, good morning. Mr. Leonard, you're here because you've been accused of one count of home invasion with a firearm or other deadly weapon. Mr. Leonard, I've read the complaint. There is probable cause for the charge, although not much more than that, but there is probable cause. Mr. Leonard, I intend to set your bond in just a moment. I'm going to see if the attorneys have any additional information before I set that bond. Mr. McDaniel, anything?
Take into consideration the complaint, the age of the defendant, and I don't know if he has any prior history, but I know he's pretty young.
Miss, thank you. Yeah, and I know that you don't see these criminal histories under the Supreme Court rules. Mr. McDaniel, I'm showing a 2022 battery in Marion County, but then I'm showing a 2025 Juno 25 domestic battery by strangulation that was dismissed by the state in September. So that's all I'm showing, but that's what I've got. Mr. Mitchell, anything?
We just request that, in addition to any other conditions, he not possess any firearms.
So thank you. So this is the dilemma this kind of complaint puts me in, just so you can talk to the officer. The allegations are this home invasion robbery happens. Gentleman wakes up and somebody's got a firearm shoved in his face. And then it says through investigative methods, that's probably the language they used, was developed as a possible suspect. Doesn't tell us how. And then there's a lineup which creates probable cause because allegedly the victim picks him out of a lineup. So what they've got right now is a victim picking him out of a lineup or alleged victim picking him out of a lineup. That's it.
I got you.
So it would help me, one of the other things that the officer needs to understand is for bond purposes, evidence of guilt is a factor in the statute for me to consider for bond. So the more evidence of guilt that they put in the complaint and their basis for it, theoretically, the stronger the case is, and therefore the higher the bond may be. Mm-hmm. So in this case, I have no idea how they developed him as a suspect because the officer decided not to tell me that. And if it was a confidential informant, all they had to say was they received an anonymous call. But I have no idea if there were other evidence of guilt other than a person picking him out of lineup, which is substantial, but it doesn't help me a lot for bond purposes to know the big picture. So given all of that, I'm going to set your bond at $25,000 cash or surety. At this point, it's a very serious charge that you're accused of, Mr. Leonard. If there's additional information that may justify a lowering or the raising of the bond, then either the state or defense can file a motion to do so and list that additional information. That'll be heard by myself or by Judge Garcia. But your bond is $25,000 today with a condition that you not possess any firearm, because that's what you're accused of doing, is possessing a firearm during a home invasion robbery. Mr. Leonard, we're also going to ask the jail to give you a notice for your court date, which will be January 6th at 8:30. Mr. Leonard, do you have any questions?
No, sir.
All right, sir. Wish you the best.
Your Honor, he also no contact with the victim.
Yes, thank you. No contact with the alleged victim also, Mr. Leonard. I think that brings us to Gregory Allday. Mr. Allday, good morning. You're here because you've been accused of violating the terms of your probation in 24523 MM. Mr. Allday, the allegation is you did everything that you were supposed to do on probation, except during the year that you had, you never went to the anger management counseling. It looks like you paid the court costs and fines and reported in like you're supposed to. He just didn't get that last thing done. Is that right, Mr. Goodson? So I'm going to appoint the public defender's officer to represent you and see where we stand, Mr. Allday. Listen to Mr. McDaniel, please.
Your Honor, I spoke to Mr. Allday. He's going to admit that he violated his probation, understanding that he'll be sentenced to 10 days in the county jail. He'll have 1 day jail credit, and he's going to waive any prior jail credit prior to yesterday. And that'll resolve this case today.
Mr. Mitchell.
That is agreeable with the state, Your Honor.
Thank you. And Mr. Allday, I was hoping you would show up and say, hey, I did the counseling. I just never got the certificate to my probation officer. I'm assuming that's not the case. Were you able to get any of the counseling done? Were you able
No,
to get
sir,
any of
I
it
had
done?
started.
Okay.
I had started them, but I was working so late. I didn't get home till after 8 o'clock.
Okay.
So I never really got.
That's what I want to know, because if you
Yes,
had to do
sir.
12 classes and you did 10, I need to know that. That may change the sentence. On the other hand, if you say you started and you did 1 or you never even went to the first one, then it's probably going to be what was agreed on this morning.
So he did 3 of the classes, Your Honor, and he just said he didn't have time with his work schedule. He didn't have time to finish up all of them. So
Mr. Mitchell, any objection to giving 3 days credit off that 10?
No objection.
So I'm gonna give you a total of 4 days credit, 1 for the day you did in jail, 3 for the classes you went to. That leaves you 7 days credit. So I'm gonna accept your admission that you violated terms of probation, sentence you to 10 days in jail, but you have credit for 4 days now, 4 days total credit that you've served. That means you've got 6 days left, no probation involved. You've already got the court costs and fines paid. So you finish that 6 days, this case will be over. Mr. Allday, do you have any questions?
No, sir.
Wish you the best, sir.
Thank you.
Mr. McDaniel, that's everything I had on my list. I do have a scheduling issue. Oh, we'll talk about that in just a second. So, Mr. McDaniel, anything else from the first appearance docket that we need to take care of this morning for the public defender's office?
no, Your Honor.
All right, as they wrap up there, let's go to Texas, 9 to 11% more. Judge Boyd, we'll get started with that right now.
Halsted, can you remove your cap, please?
Yeah.
Thank you. Judge, if I may, there was a status report, a consideration for extension sent in last week, I believe, asking for an extension, and you asked for this compliance hearing to be set. There, Mr. Halsted is being supervised out of Travis County, and there are a couple of concerns. He was due to expire on December 5th, but he has an outstanding balance, and he recently tested positive for cocaine. Following his release from safety, he stated he had trouble gaining employment, and he also learned that he has a child that he was unaware of.
All right, everyone, please whisper. Yes.
He said that he's willing to start making his payments bi-weekly.
However, no payments have been received to date. When we asked about his recent positive urinalysis, he stated he was gathering with friends who was consuming alcohol and using cocaine. However, he denied the use. So he stated he attempted to wipe the residue from a table with his hands, and he believed that contributed to his positive UA. That's where we are, Judge. Miss Osborne is the assistant probation officer assigned to Mr. Halstead's case. She is here in San Antonio. The probation officer in Travis County is not on Zoom.
All right. So, Mr. Halstead.
Yes, yes, ma'am.
So you're on deferred adjudication. The range of punishment for this offense is up to 20 years in the prison. Do you understand?
Yes, yes, Your Honor.
So here's the thing. The story about how or you're testing positive, you're not supposed to be around persons who are doing that because your number one priority should be your sobriety.
I understand.
And what you should have learned in SafeP and what you learned in the outpatient aftercare is that you have to change people, places, and things. And changing people, places, and things, I know is very hard. Because if you were to come to me and say, Judge, you need to change people, places, and things, I want you to start hanging around with people who drink excessively and do drugs. My thing would be, okay, where do I find these people? You know, are these people going to be accepting of me? So I know that's a big turnaround for you, but you're not allowed to do that. Do you understand?
I understand.
So with regards to your positive for cocaine, are you taking any sober support meetings at all? Are you doing that?
I was doing AA and NA, but I haven't as of recently. No, ma'am.
All right. And see, that's when you start backsliding. When you put off doing certain things and you know you need them in order to maintain your sobriety, when you look up, you're no longer on the path that you're supposed to be on, and you're using, and you see that you haven't been to a NA or AA meeting or sober support meeting in months. You can't do that.
Right.
Based upon what I'm seeing with this status report, you cannot be around other people who are doing drugs. You cannot be around other people who are drinking alcohol. And sometimes when people use cocaine, they're like, oh, well, I can drink alcohol. No, you can't.
Right.
And you're not allowed to drink alcohol while you're on probation. Because at the end of the day, it really doesn't matter what your friends are doing because they're not on probation with the court. You are. You understand? And
yes,
you could have completed this probation, but for the fact that I received this report. So one of the things we're going to do is your conditions are going to be altered and amended. And I've already had you extended to March 2026. So that's how far your extension is. And whether you are extended again is going to depend completely upon you, because I can extend you up to 4 years. So there are not going to be any more positive UAs from you. If you need help with your sobriety, you're going to reach out to your probation officer and going to say that you need help.
Right.
But for now, probation, I'm going to want sober support meetings for him at least 2 times per week. And if you need to do more than 2 per week to maintain your sobriety, that's not going to look poorly upon you. That's you learning what you need in order to maintain your sobriety. So you're going to do sober support meetings 2 times per week. I see that you work, but you get sober support meetings are all over the state of Florida, all times of day and night. And then with regards to this balance, realistically, how much would you be able to pay towards that per month, you think?
Well, I don't have an exact number. I came up with a number, and I'm going to be honest, I didn't write it down, but I'm thinking if it's $150 $50 a week, whatever. So what's that? 600 a month. I think that's what that comes out to.
Okay, so here's the thing. I don't want you to tell me what you think I want to hear, because I'm looking at this and they say that you're earning $15 per hour.
Right.
Are you still doing work as a groundskeeper?
I'm with a company called Precision Pearl. I don't know if that was like a misunderstanding, but it's like I work on mandolins, which is an instrument. I work for like a company that customizes mandolins for like bigger companies. So, Gibson and things like this. They come and they ask.
So your
Right.
employment has changed, because they had it down as groundskeeper.
I mean, I don't know how I got groundskeeper even on there to begin with. I don't know if it was a miscommunication, but since I've been out, the only job that I've had has been this job. So
let me ask you this, just as a side note for me, do you enjoy working on mandolins?
I really do. It's been one of the best jobs I've ever had.
Oh, wow. That is so awesome. So for that job, how much do you make per hour? Are you paid on salary?
That's the right amount. I mean, I don't know where they got groundskeeper. I think it might have just been a miscommunication. But no, I'm not salary, I'm hourly.
Okay, and it's $15 per hour?
Right.
Judge, and I would like to point out there is no type of restitution or anything included in that number. That is still outstanding.
Okay.
Yes, ma'am.
All right, so this is what I'm going to ask of you. And if you're unable to do it, let me know.
Okay.
Are you able to pay $500 in 3 months?
$500 in 3 months. Yeah, I believe I could do that.
All right, so I'm going to ask that you pay $500 by March. We will say, I'm going to ask that you pay that by March 2nd.
By March 2nd?
Yes. And how long is his probation extended to in March?
Judge, it would be March the 5th of
All right.
2026.
So you need to have that paid by March 2nd. And then I'm going to want 2 sober support meetings per week.
Okay. Can I read this back to you? I have March the 5th is when that's the 6 months. You want sober support meetings. Is it 2 times a week?
Yes.
Okay.
And then by March 2nd, you'd have paid $500.
Okay, I got it.
I'm sorry, Judge, I misspoke. In the system, it says that his expiration, I think on the note that you put in on the supplementary report, it just said March of 2026. So they included the entire month of March.
Okay.
So it says March 31st, 2026. I just want to make sure that you're aware.
Okay, thank you. So by March 2nd, you'd have paid $500 and you're to do 2 sober support meetings per week.
Okay. Yes, ma'am.
All right. And Officer Osborne, is there anything else you suggest?
No, ma'am, not at this time.
All right. So, Mr. Halstead.
Yes.
Don't test positive. Follow these rules, and I will consider terminating your probation early.
You will not have any, there will be nothing to worry about. I mean, I'm going to just put my head into work and do my 2 meetings. That's exactly what I'm gonna do and nothing more. I'm gonna go to work, go to meetings, and that's it until this is done. I got kids. I'm really disappointed in myself, to say the least.
All right, I want you to be successful at this probation. I take no joy in sending people to prison, no joy in extending people, because if people can be rehabilitated and be successful, then that'll be less people for probation to have to supervise. All right. And maybe when you do your sober support meetings, you'll be able to meet friends there who are, on their journey of sobriety, and make sure that you get a sponsor, because that's somebody you can always call if you feel as though there are going to be some issues, or, maybe you're about to slip. And also let probation know if you feel as though you're going to use, let probation know. I have the final say on whether or not a motion to revoke is filed against you, because motions to revoke come to me. I look at it, I sign it. And as you can see, when it's an issue of maybe someone tested positive, I like to have a conversation to find out what is going on in your life and if there's anything that we can do to get you back on track.
Right. I mean, if I'm gonna be honest, which I am, I wouldn't say that I have like a constant urge or anything like that. I'm trying to just say it exactly how I feel. Is that, I've been out, I've been good, I've been taking care of my kids. I found out I had a son, I was doing everything right, and I don't want to put nothing on nobody else. I'm my own man. I did what I did. There was a lot of things going on. I don't have family because of this case. Like, it's hard to, I don't really have anybody to lean on. So I did have a sponsor, so I'll get back in touch with him. He was at the halfway house that I was at. It was like a counselor, so I can get back in touch with him. And as far as the only one thing I just wanted to be clear on was the 2 classes. When I go to my next meeting, do y'all have like some sort of list that, where I could go to in Austin, or I don't.
Well, are you in Austin or are you in Florida?
I'm in Austin. I don't know.
All right. See, there's something else. All right, let me do this. Just one second. All right, let me ask you this. Do you have access to a computer, or does your phone have access to the internet?
Yes.
All right, if you go on the internet and if you just type in sober support meetings Austin, you should pop up and it'll have an entire list. And if you go to communities in recovery, let me see, just one second.
Okay.
Are you able to see that?
Yeah, I am. I can't see the actual like the website. It's too small.
Well,
but
at the top it says community and recoveries, and if you scroll down, they even have online meetings.
Right.
And so some of them have online meetings, and you can go there, or there are other places also. And all of these sober support meetings that you go to are actually free.
Okay. Can I tell you something that I ran into while I was doing it was when I was doing the Zoom ones, and I don't know about these, so I'm going to check on these, but when they didn't correspond with court, so like asking them for some sort of proof was like, I ran into a couple of meetings where they said they don't do any, like, because it's supposed to be anonymous, so that I don't know how, it was a bit of a weird thing, because I felt like, I'm here for this reason. I just need proof that I'm here. So
what you can do is if you'll take in a sheet of paper right?
Right.
And on that sheet of paper, you just write the dates down, and whoever is leading the group, just ask them if they will sign that or initial it to show that you actually attended, and let them know that you need it for your probation. And normally they will initial it.
For signature. Okay.
And if you ask your probation in Austin or Miss Osborne, if you're able to help with that, maybe Austin has a sheet for him to give him, because I've seen some defendants, they actually have a sheet that probation has given them where people can sign off that they've actually went.
Yes, ma'am. I'll go ahead and give him the login sheet, and I'll also get in touch with the CSO in Austin to see if there's any agencies that they work with directly.
All right, what I'm going to do is Mr. Halstead, do you have any more questions?
No, I do not.
All right, so what I'm going to do is I'm going to create a breakout room, and I'll send you and Officer Osborne to a breakout room. And then once you all have finished your discussion, you may just leave the Zoom. But so for you, you're going to attend 2 sober support meetings per week, and you're going to pay the $500 by March 2nd. And there's to be no positive UAs from you. And if you feel as though you're going to use, reach out to your probation officer or reach out to your sober support counselor, okay?
Yes, ma'am. That's not 6 months, right? I got a little confused there. So
it's not 6 months.
Okay, but that's what you want. You want. I understand that that's what you want. I just was a little confused about the time there. So there's no problem here. I could 100% have that done.
All right. And then after that, if all of that is completed, I'll consider terminating your probation, okay? It's completely up to you whether that happens or not.
It's going to get done. It will be done.
The ball is in your court.
I appreciate your time, Your Honor. I really do. Thank you very much.
All right, thank you. I'm going to send you both to breakout room number 1, so just join.
All right.
Okie dokie, friends. Let's stay in Texas, but we'll head to Jefferson County. However, it'll be Judge West. Say good morning to her.
And Mr. Williams, in cause number 25, DCCR 1254, you're charged with the state jail felony offense of evading arrest or detention with previous conviction. That is from August 14th of 2025. The indictment alleges that you were previously convicted of evading detention in Harris County, June 4th of 2007. And so that prior evading is what makes this a state jail if you were found guilty. Your indictment further alleges that you were convicted of the offense of burglary of a habitation with intent to commit theft, a second-degree felony, February 1st of 2006 in Harris County. And then after that was final, you were convicted of aggravated assault with a deadly weapon, a second-degree felony, December 10th of 2009, also in Harris County. If those 2 prior convictions are true, then what that means is if you go to trial and you're found guilty, then the range of punishment would be enhanced to that of a second-degree felony, which means your minimum punishment would be 2 years in prison up to 20 years in prison. Do you understand? Okay. And so I know you've talked with Mr. Lewis about what I'm sure the state's offer is, and do y'all have an announcement? Yes.
No.
Correct. Yeah. So if the way it's indicted, and if those prior convictions are true, if you were actually convicted and you were convicted on different dates, like it says, then this becomes a second-degree felony for punishment purposes. So whether you go to a trial or whether you negotiate, the only way for it not to be is if the state elected not to go forward with that, and that is completely up to them. And if they have given you an offer that does not do that, then that's what the offer is. You either take that offer or you go to trial, knowing that if a jury finds you guilty, what that range of punishment is 2 to 20, not the state jail. Do you understand? Okay. Do you want to talk some more to Mr. Lewis about your options, or do you know what you want to do?
4 years, TDC.
I'll hold it. Y'all go visit for
Yeah,
a few
just,
minutes and just let me know if you need more time or anything. Mr. Wilkerson, you have John Jones.
There's paperwork that needs to be signed.
Okay, I'll hold it for just a minute. Oh, they're rejections?
Two of them are, one was Senate as agreed, he's maxed out on the state jail, but Mr. Coleman doesn't want to.
I don't want to do a piecemeal, Judge. If either we wrap them all up or we don't.
So.
Okay.
I mean, I don't know what the point of not giving him the max with no other.
The point is to dispose of all the cases at one time.
That's fine. I mean, you don't have to waive your right to trial. It is what it is.
Okay. So do I have rejections then on the others?
Yes, Judge, you should.
Do you have rejections?
And
Okay, just have a seat for a second. Let me hold this, and we'll, if you, and so you don't want to go forward with a plea to the max in the state jail. So just delete that when it comes through the state jail paperwork, and you don't necessarily need,
Like state, yeah.
if you want to do a rejection, I guess. Otherwise, I can just write it in on the other ones.
Please.
It'll be fine. Okay, I'll hold it. And then you've got a Dalvius Williams.
Yes, Your Honor. And we'll probably do the state jail as an open.
To me or the jury?
To the court. I mean, there's no enhanced, it's like it's, anyway. So, Judge, on Mr.
All right, so hold on. You're Dalvius Williams, and this is 25 DCCR 0176. Mr. Williams is charged with injury to a child, elderly, or disabled individual, and what is the announcement?
Your Honor, Mr. Williams, and I filed the motion in this case after I explained and sent Mr. Williams a communication explaining what he was subject to in terms of punishment and what the state has indicated their enhanced punishment range and a motion to accumulate coming on a jury trial. He immediately told me he did not want me to represent him because I don't show his best interest. He would like to fire me, so.
You're court appointed, right?
Yes, Your Honor.
You don't get to fire your court appointed lawyer. You can fire someone you hire. Mr. Wilkerson is an excellent attorney. He handles many cases for all of us here in Jefferson County. If he's advising you of whatever your situation is, then your situation is what it is. So we can go through and what you're charged with and make sure we're all on the same. I feel like we've done that before because we've already had a plea bargain rejection, but let's do it again. It looks like you're charged, it's a 3rd-degree felony, which means the punishment range is between 2 years and up to 10 years. However, it looks like, has there been, I don't see a notice filed of extraneous, but are there some that you
Yes.
anticipate filing?
Yes, Your Honor.
Mr. Smith?
Yes, Judge.
2 prior state
There's-
hearings.
Well, there's a 3rd degree. Excuse me, Judge.
Hold on just a second while they get this figured out, and then I'll let you ask any questions you have, okay?
No, come with me.
So Judge, there's a state jail for criminally negligent homicide. There's another state jail for attempting to take a weapon. And then there's the third degree that Mr. Smith mentioned. There are no other TDCJ convictions.
So the third degree felony conviction, if true, would enhance your punishment in this case, if you were found guilty, to the second degree range of punishment, which is between 2 years and up to 20 years. Do you understand that? Okay. And it looks like we previously did a plea bargain rejection, and at that time, the third degree felony was checked off instead of the second degree admonishment. But I do want to make sure you understand today that if you go to trial and if that conviction for the third degree felony, the state jails don't enhance you, but the third degree would to a second degree felony range of punishment. It looks like that rejection was for a 4-year term in prison. Is that still the offer?
That was the offer as of this morning.
Okay, so the offer is for 4 years in prison. You already said that you didn't want that. If you want to change your mind after discussing your options with Mr. Wilkerson, then we can take care of that. If you don't, then we'll set your case for trial. Mr. Wilkerson will prepare for trial and we'll get it taken care of as quickly as possible. Yes, sir.
There was one more thing. The state had indicated an intent to file a motion to accumulate. He just had an 8-year sentence on an MTRP.
If you recall, Judge, we had a motion, a contested motion to revoke probation with this as the allegation. We proved that up. You gave him an 8-year sentence.
Okay.
So that 4-year sentence that we had offered today was to run concurrently with that.
Okay.
If he rejects that, then we will file a motion to stack whatever he receives from the jury in this case on that 8 years that he's already served.
So I want you to understand, so the third degree conviction, is that something other than the conviction? The revocation, or that's the one that?
The revocation was for a injury to a, so that was,
The prior conviction that y'all are talking about, that third degree,
That's on the MTRP.
That's on the MTRP?
Yes.
And so, does everyone agree that timing, though, the conviction of that?
I see what you're saying. I don't think that one does, but I think the 2 state jail felonies bump it up to a 2.
They don't do anything. State jails don't do anything to a TDC case. And if I convicted him on an MTRP after this offense date, then he wasn't convicted on the offense date, and so that doesn't make it sequential. Am I right?
I think you are right, Judge. So I do think it goes to the.
I don't disagree that there could potentially be a cumulative request, but I don't think it would enhance his punishment because I think it has to be a prior felony conviction before the date of this offense. Help me out. Am I right? I'm looking at all the lawyers. Everybody?
I think you are, Judge. Yeah.
Okay, so forget everything we just said. The range of punishments between 2 years and up to 10 years in your case. The state's offered 4. You can take your 4, you can go to trial. Mr. Wilkerson will remain your attorney. So what do you,
I want to go to trial.
Okay.
And I want to see what is the outcome if I can get my own lawyer.
Well, yeah, so you have the right to hire your own lawyer at any time. But because you're in custody, we're going to move forward with your case. I'm clearly going to appoint you someone. You're not just going to sit in jail without a lawyer. We're going to make sure you have representation. And your case is going to move along. So if your family or you has the funds to go hire someone, then by all means, you need to get them hired and they can substitute in and they need to get ready for trial also. Until or if that happens, if it doesn't, we're going forward, case will be on the trial docket, we're going to move forward. We're not going to keep putting it off for that to happen. If it happens, great. But as of right now, you're rejecting the 4. I also want to make sure you understand, Mr. Smith, is there any reason to believe that that offer of 4 would change?
No, Judge. And in fact, we had offered to dismiss the case against the co-defendant in this case for his plea in this case to run concurrently with the time he's already served. In fact, it would be for less time. So
Okay, so I do want to make sure you understand that there's not going to be any new offers. It's the offer remains what it is, no matter who your lawyer is. And that there is the potential for anything you get from a jury to be stacked on top of that 8 years that you already got. You understand that too? Okay, we'll get it set for trial. You can go back with the bailiff. And so I am going to deny the motion to withdraw.
All right, let's step across the hallway. Where did my mouse go? There it is. Let's step across the hallway and go back to Judge Stevens.
It's Edwin Jones, you know, Mr. Jones. Okay.
We were here just a couple of weeks ago.
Okay,
Judge.
yeah, 21-36867, and Mr. Jones is charged with false statement to obtain property or credit of third-degree felony. And Mr. Burbank has filed, looks like a motion to withdraw.
Well, that was a long time ago.
Okay, what do we do?
Well, the
Discharge
defense
these?
had enough time to get the information that the state wants.
Okay,
So I just asked for another 30 or so days and so we could work this out. This is one that another prosecutor had, and we don't understand why it's not in the federal government.
yeah, but that's all, but what I don't understand is it's going on 5 years old. Since it's filed April to 21. That never happens here. Yeah, well, that's what, there it is. April 14th, 2021.
I haven't had
My
it.
daughter's birthday.
Yeah, I haven't had it that long.
Nonetheless, we gotta, I mean, this has gotta be one of the oldest ones. But anyway, are we gonna be able to move it?
I just have to get the paperwork to the
Okay, how long?
30 days would be good. We've got the holidays.
It's 4 weeks.
That's fine, Judge.
Yes, sir. All right, get a resetting. Tierra Norman?
Yeah, sure.
Tierra Norman, no answer in the courtroom. I asked the bailiff to call into the hall for Tierra Norman. This is cause number 25C01242. One case is 100 years old and the other person's not even here. You're batting 1,000.
At least I'm here, Judge.
You know what? Let me just say, that isn't good enough for my wife when I say that. Okay? She does not feel like that's it. Yeah, needs work. At least I'm here. I mean, really? I mean, I bet you said that. Yeah, that's.
She was in my office.
There's no answer?
She was there yesterday? Yeah, she came to
No response to that name being called here in the courtroom. No response to the name called into the hall. Defendant is failed to appear. A warrant shall be issued for her arrest.
Could you check?
Her bond is in the, could I check the jail?
She has a warrant. MGRP.
All right, well,
It's in my office.
maybe she is.
Judge.
Uh,
And I told
But
her
we're
what
gonna
to do.
tentatively finish this.
It's 7,500.
Okay.
Yeah, but is there, do you see? is
Hold
that
on,
the-
hold on. Let me finish this and then we can, the court is going to revoke her bond for failure to appear. It is doubled to $15,000. Plus she must have a GPS as a condition of bond. And this is conditional, the staff will check the jail to see she's not in the jail.
Not in jail. Huh.
But she does have a warrant for her arrest.
And there's so,
Yeah, it was
On
no
that
bond. It was
application.
no bond, right?
With a no bond.
Yeah, and I filed a motion yesterday for a bond, Judge, but I thought she was gonna be here tonight.
that doesn't help you.
Oh, here she is.
Nice try.
Come on, don't wait. See, here she is. There's a warrant for you. There's a warrant.
Come on, come all. Mr. Burbank is accepting any clients now, anyone at all, anyone at all.
Might be experienced. I think that's it.
Hey.
Yeah.
All right, well, they try to invent a contestant out of thin air, apparently. Let's go back to Judge Boyd.
All right, the court is calling 2023 CR 10232 State versus Richard Gonzalez. Can I have parties announced for the record, please?
Megan Galloway for state.
Alexander Kraus for the defense.
And are you Mr. Gonzalez?
Yes, ma'am. Good morning.
Good morning. All right, did you review the document entitled Motion to Revoke Community Supervision and state's motion to supplement pending motion to revoke probation with your attorney? Did you understand it?
Yes, ma'am.
Are you the same Richard Porfirio? Thank you. Gonzalez, who is placed on community supervision for the offense of unauthorized use of a vehicle on December 19th, 2023 for a term of 2 years. Is that you?
That is correct.
All right, state.
In violation of condition number 4 in Barrett County, Texas, the defendant Richard Porfirio Gonzalez did then and there fail to report to the supervision officer as directed for the months of February, March, April, May, June, July, August, September, and October 2025 in violation of condition number 4.
How do you plead to that? True or not true?
True.
And we waive and abandon the remainder.
Any objections to the waivers?
No, Your Honor.
Did you understand by pleading true to violation of condition number 4, the court could find it true, grant the motion, sentence you to 2 years in the state jail facility and a $1,500 fine?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 4?
True.
No. Do you understand that if you have an agreement with the state, I'm not bound by any agreement that you've reached with them? Do you understand that?
Not entirely, no.
All right. So let me explain it to you this way. When you were placed on probation, you entered into a contract. That's what
Yeah.
probation is. It's a
Okay.
contract.
Yes.
And in that contract, it tells you what is expected of you.
Yes, ma'am.
All right. So you just pled true to not reporting for several months.
Yes, ma'am.
So part of your contract was you were to report.
Yes.
You understand that? So the contract that you have is the contract, it's a contract between you and the court.
Yes, ma'am.
It's not a contract between you and your attorney or a contract between you and the state.
Yes, ma'am.
If it were a contract between you and your attorney, then we wouldn't be here because
Yes.
your attorney could say, you know what, I forgive you, we're going to keep going on.
Yes, ma'am.
So sometimes in motions to revoke, the state will negotiate with your counsel and they will say, hey, this is what we're going to ask for. Well, regardless of what the states ask for example, let's say in this case, the state were to ask for 180 days. I don't have to follow that because I don't have a contract with the state. They're not a part of this contract. I could say, no, I'm going to give you 2 years. Do you understand?
Yes, ma'am.
So knowing that, do you still wish to plead true to violation of condition number 4? All right, the court will find violation of condition number 4 true. Is there a proposed agreement?
Judge, we're asking for revocation in 1 year in state jail.
All right. So, Mr. Gonzalez, you want to raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand, state your name for the record.
Richard Porfirio Gonzalez.
All right, so why didn't you report?
Was when upon leaving the program, when I got home, I found out that I was homeless and I was looking for my wife at the time. She was also homeless. Since then, I've built I got my own business now where I got Gonzalez Automotive, Gonzalez Tree Care and Landscaping. I got an apartment now. My wife is 3 months pregnant, so it's.
I'm sorry, you said your wife is what?
3 months pregnant.
Okay.
So I have my son as well that I take care of, and then I'm actually moving on,
And how old is your son?
He's 12 now.
And who is with him now?
His mom.
Okay.
But that's with his mom, and then I have my wife, who I'm with now.
So that still doesn't explain to me why you didn't report.
I was homeless and I was looking for my wife. And I didn't know where she was at. I had no source of communication with anyone. I messed up. I understand that. It's just, I was worried about my wife, trying to find her. I didn't know where to look, how to find her, where to, nothing.
But see, you'll see that you can look for your wife and try to find her, but you can't look for probation and go into probation.
I understand that I messed up. I wish I can get, I was trying to get past, of my mistakes.
All right, has restitution been paid?
No, Your Honor.
All right, probation, is there, in the original plea bargain agreement, it said that there is to be restitution of $2,000. Has that been paid?
No, Judge.
All right. And then this is not his first motion to revoke, is that correct? All right, and your previous motion to revoke, what was that for?
I was sent to another county. at the time.
No. They don't file a motion to revoke because you've been transferred.
Right, when I got out of there, that's when I found out I already had a warrant set here for that.
No, on your very first motion to revoke.
That's what I'm speaking.
All right, so
I had,
what were they saying you did not do in your very first motion to revoke?
I didn't report. But see, I was in another county and there was nothing I could do. I was in another county. I was in Frio County at the time.
All right.
So when I returned back to San Antonio, there was already a warrant issued.
All right. Your problem is you're not really on probation. And when I say not really on probation, you haven't done anything.
No.
So this is what the court is going to do. The court is finding violation of condition number 4 true. The court is going to revoke. The court is going to sentence you to 18 months in the state jail facility, give you credit for any time served. And did probation, did he successfully complete ISF?
Yes, Judge, 90 days.
All right, and I'll give you credit for any time served in ISF. All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal? I'm sorry, State, you may be excused.
Yes,
Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, ma'am.
All right, you have a limited right to appeal. That right to appeal is as it relates to the allegations in the motion, not the fact that you are on community supervision. I'm sorry, Ms. Abrams,
Yes, Judge.
was there restitution ordered or any restitution for Ms. Goodwin?
Judge. I think have the amount of $2,000 to Ms. Goodwin.
All right, and there's to be restitution of $2,000 to Molly Goodwin. All right, because this was not a plea bargain agreement, I'm going to repeat it. You do have a right to appeal. That right to appeal is limited to the allegations in the motion, not the fact that you're under community supervision. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, good luck to you, okay? Thank you.
Thank you, Judge.
Okie dokie, Texas is totally where it's at the moment, so let's go back to Judge West.
All right, sir, you're John Jones? Yes, ma'am. Give me just a second. Let me get your, everything pulled up here. See, Mr. Jones, in cause number 25 DCCR 0523, you're charged with a first-degree felony offense of murder from April 28th of 2025. And what that means, sir, is that if you go to trial and you're found guilty in that offense, the range of punishment would be between 5 years and up to 99 years or life in prison. Do you understand the range of punishment?
Yes, ma'am.
And then in cause number 24, DCCR 2431, you're charged with a state jail felony offense of unauthorized use of a vehicle from October 15th of 2024. What that means in that case is that if you go to trial and you're found guilty, the range of punishment is between 6 months and up to 2 years in the state jail prison. Do you understand?
Yes, ma'am.
And then in cause number 25 DCCR 1352. You're charged with a first-degree felony offense of aggravated robbery from September 18th of 2024. What that means in that case is if you go to trial and you're found guilty, the range of punishment is a minimum 5 years up to 99 years or life in prison. Do you understand?
Yes, ma'am.
And then finally, in clause number 25 DCCR 1353, you're charged with the second-degree felony offense of robbery from September 18th of 2024. And in that case, what that means is if you go to trial and you're found guilty, the range of punishment is between 2 years and up to 20 years. Do you understand?
Yes, ma'am.
And then I have here on the tablet, in those cases, some plea bargain rejections that you've signed with Mr. Wilkerson. They show that the district attorney's office has made an offer, if you wanted to enter pleas of guilty, for a 35-year term in the murder case to run concurrently with a 35-year term in the aggravated robbery case, with a dismissal in the robbery as well as the state jail felony unauthorized use. Is that correct?
Yes, ma'am.
Do you understand what their offer is?
Yes, ma'am.
And have you gone over it with Mr. Wilkerson?
Yes, ma'am.
And do you want to reject that offer and have all 4 of your cases set for trial?
Yes, ma'am.
All right, is there any reason to expect that those offers would change any evidence that you're waiting on that you guys haven't received or gone over?
No, Your Honor, not at all. In fact, the state will likely be filing a motion to accumulate the sentences to the extent that we can. I think 3 of them would come out of one occurrence, and then there's one from a separate occurrence.
You've actually got 3 different dates. So you've got ag robbery and robbery from September of 2024. You've got an unauthorized use from October of 2024, and then the murders from April of 2025.
To the extent we can accumulate all of those, Judge, we will seek to do so.
So I want to make sure you understand, Mr. Jones, that if you are found guilty in more than one of these offenses by a jury, the state can file requests that I stack or run cumulative, which means stack on top of each other any punishment that you receive. Do you understand that as well?
Yes, ma'am.
And that after today, I will not accept this agreement for a 35-year term. If you change your mind later, you can enter a plea open to the court. You can enter a plea to something different, but it's not going to be 35 years. Do you understand?
Yes.
All right, and do you want to have all of your cases set for trial?
Yes, ma'am. I got a question though.
Yes, sir.
It's my offer 35, right? Like that's what the DA's offer, right?
Uh-huh.
My co-defendant admitted to it, but he got a 30-year offer.
Here's the thing. Your offer is what your offer is. He may or may not have had the robberies before he would, listen, I don't know. I know the offer is what the offer is. All right? So either you take the offer or you go to trial and let a jury decide. I'm not involved in negotiations. I'm not going to tell the district attorney's office what to do. That's not my job. But you don't get to, everybody has different issues in their cases that they feel important and why they would make different offers for different co-defendants. All right? So you're not going to have a different offer, and that's what I want to make sure you understand. Even though there was something different for your co-defendant, the district attorney's office has said, this is it, this is your offer. Do you understand?
Yes, ma'am.
Okay, and you want to reject it and go to trial?
Yes, ma'am.
Okay, we'll get it set for trial, and Mr. Wilkerson will begin preparation. You can go back with the bailiff.
Thank you, Your Honor. Be excused.
Thank you, sir. Everybody's looming. Let's see. Is there a Mr. Zuniga here? Mr. Rojas, you have Glenda Williford? Good morning.
So while we're waiting for the next contestant, I just put a poll up. If you had a 35-year offer, but you were facing life if you went to trial, would you roll the dice? Let me know.
The client waived the formal reading of the motion.
She will, Your Honor.
Give me just a second to get that pulled up.
Our agreement, Your Honor, is for her to go into special needs safety.
Thank you. Sorry, it's taking a minute for my computer to get pulled up here. Okay, so Ms. Williford, in cause number 24, DCCR 1720, I have a motion to revoke your unadjudicated probation. It shows that you were placed on probation December 3rd of 2024 for the second-degree felony offense of aggravated assault with a deadly weapon, and that was a 5-year deferred probation. Is that correct? It alleges that you violated your probation. Count 1 alleges that...
Judge, we've agreed to go counts 3, 4, 7, and 8.
Thank you. 3, 4, 7, 8. Count 3 alleges that you provided a urine sample August 14th of 2025 that tested positive for tetrahydrocannabinol. Is that true or not true?
Yes.
True or not true? Count 4 alleges that you provided a urine sample September 18th of 2025 that also tested positive for tetrahydrocannabinol. Is that true or not true? Count 7 alleges that you failed to provide verification of entering and successfully completing the anger management program. Is that true or not true?
Sure.
And then count 8 alleges that you are behind in your court-assessed fees as of September 18th, 2025 in the amount of $688. And is that true or not true? Did you enter your pleas of true to counts 3, 4, 7, and 8 freely and voluntarily? And did you plead true to those counts because they're actually true? I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Rojas? Do you fully understand them?
Yes.
And do you understand if I follow this agreement that you've made with the district attorney that you'll be waiving or giving up any right to appeal?
Yes.
Speak up, please.
Yes, ma'am.
And it looks like the agreement that you've reached is to remain on probation, but enter and successfully complete the special needs safety program. Is that your understanding?
Yes, ma'am.
And we've got probation here with us today. And is that the recommendation from probation as well?
Yes.
Okay. I am inclined, if I follow this agreement, to extend the probation by some amount of time, just based on the allegations and the time that'll be spent there. So I want to make sure there's plenty of time after that she has still on probation. State tenders number 1.
No objection.
It's admitted. Is there any evidence that Ms. Williford is not competent?
Okay.
All right, ma'am, I'm going to find that you entered your pleas of true to counts 3, 4, 7, and 8 freely and voluntarily. Find sufficient evidence to find you guilty and revoke your probation, but I'm not going to do that today. It looks like there's some everybody's willing to work with you, but I want to make sure you understand that we're going to send you to the special needs safety program as a condition of your probation. I'm going to extend your probation by 1 year, and this is going to be, hopefully, listen carefully to what I'm saying, okay? Because this is the second chance you're being given, and there will not be a third. So you need to take advantage of every opportunity that is being given to you. You're going to get help with drug abuse. You're going to get help with mental health, with everything you need to be successful when you get out of safety. If at that point you don't follow through and do what you're supposed to do, you're going to be back in here and you're going to be looking at going to prison for up to 20 years. You understand? You okay? Are you okay? You're getting white. She's getting white.
I had a statement prepared for you, explaining the only reason I was doing marijuana at the time was because of my cancer, my pain management for cancer. And I will promise you on Jesus' happy golden good soul that I will never touch the shit again if you let me go home.
Are you seriously going to stand here and talk like that?
No, ma'am, I didn't mean to. I'm terrified. I'm so sorry, ma'am. I just didn't realize how much trouble I'd get into.
You're on probation for a second-degree felony, an aggravated assault with a deadly weapon.
Yes, ma'am. I realize that.
There's all kinds of other ways to deal with issues, and there's definitely more respectful ways to speak to the person who could put you in prison for up to 20 years. I don't have to go along with this plea agreement right now. Okay. I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. Go back with the bailiff.
Austin wondered what she said to the judge. She used a swear word. Not directed at the judge, but just inappropriate language. All right, let's move from one older female defendant to another, I guess, and go back to Judge Boyd.
Any applications?
Yes, Your Honor.
All right, the court is calling 2025 CR 004627 State versus Alfonso Lopez. Could I have parties announced?
Lauren Espinosa for the state.
Trey Maurer for Mr. Lopez.
And are you Mr. Lopez?
Yes, ma'am.
Counsel, have you received all discovery and reviewed that with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Lopez, did you review the document entitled Application for Community Supervision with your attorney? Did you understand it and sign it?
Yes, ma'am.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
We do, Your Honor, and just for clarity, we entered a plea in this case already. We just came back for sentencing today. There was no
You know
PSI.
what? They put the wrong stamp on this. Just a second. All right, then you're here for sentencing today.
Yes.
Let's see. According to your plea bargain agreement, the state is opposed to your application. Punishment is to be assessed at 2 years in the state jail facility. There's an $800 fine, and the state is taking in consideration 2025 PF 42484. That's your plea bargain agreement. Both parties agreed to waive the PSI and TAP evaluation. Is that correct, state and defense? All right, defense, do you have any witnesses?
No, Your Honor, I just have argument. I have a letter I'd have to tender.
All right, any objections to the court reviewing the letter?
No, Your Honor.
All right, thank you.
Thank you, Judge.
And state, you're opposed?
Yes, Judge. Would you like my reasoning why?
Yes.
Okay, yes, Judge, I do believe that Mr. Lopez is not proper candidate for community supervision. He does have 8 prior convictions, including 4 thefts. So because of his history, Judge, I don't think he would be a successful candidate on this front.
All right,
May I proceed, Your Honor?
yes.
Judge, Mr. Lopez has spent much of his adult life homeless. Just so the court has an understanding of the timeline, this case happened in July of 2024. As the court read in the letter, in May of 2025, he was connected with this program that was able to assist him in finding some housing and stability. Based on my conversations with Mr. Lopez, I think this is the first time that he's really had an opportunity to call a place home and to have a support system, have this organization helping support him. If he is given an opportunity at probation, this, like as I mentioned, will be the first time that he really has a place to call home and to be at home. This organization is going to help him get his ID and other documents together so he can apply for his Social Security. He has not been able to get that in the future or in the past, I'm sorry, due to his homelessness and not having any form of ID. So this organization is really helping him get his life on a track that it's never been on before. And I think that if he's given an opportunity to prove that he can be a good candidate for probation and that he can take advantage of what this organization provides him, as well as any conditions that the court deems appropriate. Obviously, he knows that he would have to keep up with probation, to do whatever classes and programs the court orders. I believe that those accompanied with what he has from this housing project will allow him to be successful. So we're just asking the court to give him an opportunity at that. We understand that he does have an extensive criminal history, but as I mentioned, I think this is the first time that he's really been able to put his life on a track that it hasn't been on before. So we would just ask for him to receive that opportunity.
All right. You want to raise your right hand? Do you solemnly swear and affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, lower your hand, state your name for the record.
Alfonso Lopez.
All right, so why did you commit this crime?
Well, that, I was doing kind of bad and I couldn't get my retirement.
Retirement from what?
Well, my SSI, because I didn't have an ID
Oh, SSI for what reason?
for retirement.
No, I mean, what previous employment that you have the ability to obtain retirement?
Well, I applied for Social Security and they granted, I was granted.
No, let's go back. So this is my first question. Usually when people say they're seeking retirement, right? Sometimes it's because people have worked. So what did you pay into the system that you feel that you're entitled to retirement funds?
Well, I worked a pretty good amount.
All right, doing what?
I worked at Goodwill. I worked at a good district. I worked a couple of places for a couple of years.
All right, so then now back to my first question, why are you stealing? Because your criminal history is riddled with cases of your stealing.
Yeah.
So why?
I was homeless and I couldn't get my SSI because I had this case pending and I didn't have no ID to go get I didn't have no money to go get my ID, and if I did, they were gonna arrest me anyway. So I had a no-win situation.
No. So what you just told me is that you couldn't get your SSI because you had this case pending. So we're still back to, why are you stealing?
Well, I didn't have no money. I didn't have no income, no kind of income.
So what if everybody who has no kind of income just decides to steal?
Well, I was homeless. I was down. I didn't have nowhere to go. I didn't have no.
But what if everybody who is homeless, who has no income, decides to steal? And see, people look at me and they think certain things, right? It's like everybody thinks that a defense attorney is a multimillionaire because they watch on television, or they think they're Matlock and they get paid $100,000 for every case. So I will tell you, I've been in situations where I've had zero money. When I was in law school, I had zero money for books. I had zero money to pay for food. And you know what I would do? I didn't go to the cafeteria and steal. I talked to the chef who made things. At some point, they brought in a chef and the food improved greatly. And I said, look, I'm a student here. I don't have any money. Can you help me out? And I could pay you at the end of every week or at the end of every 2 weeks. And you know what he said? Stephanie, I will. And so I would budget in my mind. And at the end of every 2 weeks, I would come in and pay him for the food that he gave me beforehand. So I don't know why people are in this mindset that, oh, I don't have anything, so let me steal. When I first came to San Antonio and lived in an apartment, I didn't have any furniture. I didn't go out and steal furniture. You know what I did? I made a pallet because I had a comforter and I slept on the floor. Had a lot of back injuries from sleeping on the floor, but I did it. I didn't go out and steal. So I don't think you're internalizing my questions because your history is riddled with your just stealing. And all of the thefts you've had cannot be, oh, I'm trying to get my SSI.
Well, I couldn't get it. I wasn't eligible to get it because I wasn't part of our at the age I was getting it at that time. And really, I don't have no excuse. The thing is that now that I got somebody helping me out, I could look at things better, because I got a place to stay and I could work things out. But it's like you said, yeah, my past on, you could say, nobody agrees with it, yeah. But I'm just asking to see if I can get this chance.
All right, and do you have any drug history?
Yes, ma'am.
And what would that be?
It was heroin, but I ain't been, see, I'm in the B Will clinic.
No. So here's the thing. You need to be 100% honest with me right now, because I'm trying to figure out whether or not to send you to the state jail facility for 2 years or not. So you need to tell me the good, the bad, the ugly. I don't know why when, as a defense attorney, I would have clients, it's like you've already pled. You got to throw yourself on the mercy of the court. So what is your drug use?
It was heroin, but
How often?
it was an everyday thing. But I haven't used it in years. I went to this clinic, B Will. I'm working with B Will. I've been with them for about 3 years already. And then they've been helping me. They give me the Suboxone to get it over with. And I've been taking them for over 3 years already.
All right, state, you've heard his testimony. Do you have any questions of him?
No, Judge.
Did you have a chance to review the letter?
I did, Judge.
All right, does that change your request at all?
No, Judge.
All right, I'll hear your final argument.
Your Honor, like Mr. Lopez said, and as we asked earlier, this is the first time that he's really had an opportunity to get his life on a different track. In the past, it's been the same situation, jail, prison, homeless. He never really had an opportunity to have a place to call home and to have this strong support system, as well as the support system of probation. I think he knows that probation is not going to be easy and it's going to ask a lot of him. But if he's given that opportunity, it will just solidify that he's made some right choices finally and is getting on the right path. So we would just ask for him to be given that opportunity to show the court that he can be successful.
All right. Mr. Lopez.
Yes, ma'am.
Always keep an open mind on everything. Looking at your history, mentally, I was like, yeah, 2 years, state jail facility. But your attorney has done great work in getting a place for you to live. People will say in this court, probation is not easy.
Yes, ma'am.
The conditions I give are hopefully designed to rehabilitate. So these are your only 2 choices. You have no other choices. Don't ask for a third.
Yes, ma'am.
I can grant your application, place you on probation. You will be on probation for 5 years. Don't come to me asking for early termination because you're going to be on probation for 5 years.
Yes, ma'am.
And your underlying will be 2, which would mean if you were unsuccessful, you're still looking at 2 years in the state jail facility. Or right now, I'll sentence you to 18 months.
Well, Your Honor, I don't really gotta say so on this. It's really up to you.
No, here's the thing. Do you want the 18 months in the state jail facility? Or do you want to be on probation for 2 years? I'm sorry, for 5 years.
I'd rather take the probation because I need this. I need this housing and this help.
All right, this is what the court is going to do. Court is finding you guilty. The court will sentence you to 2 years in the state jail facility, suspended and probated for 5 years. There's an $800 fine. Normally I probate that, but you're going to pay that fine.
Yes.
There's going to be field visits 1 time per month until further notice. Proof of employment or SSI within 45 days of release. No employment as a home health care provider or with minors. Regular reporting by Zoom or in person. Regular random UAs. There's going to be a TAP evaluation in custody. Follow TAP recommendations. And there's going to be sober support meetings. Times per week until further notice. 200 hours of community service restitution. He's going to do the theft course through CATS. And take in consideration 2025 PF 42484. Probation, is there anything else?
No, Your Honor.
Is there anything else you need from the court in order to be successful?
No, thank you.
You're welcome. Did you review this document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, ma'am.
Because this is a plea bargaining agreement, because I followed your plea bargaining agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, we can go off the record. Here's the thing. You need to follow through on all of the conditions I've set for you. If you violate this probation, you're looking up to being sentenced to 2 years in the state jail facility. Do you understand?
Yes, ma'am.
Your attorney said, and you said that you want to change your life. This is your chance to do that.
Thank you.
All right, good luck to you.
Thank you, Your Honor. Maybe excused?
Yes.
So a lot of talk in the chat about whether or not this defendant will actually be able to change his life as he says he wants to do. The consensus seems to be you'd love a heartwarming story, but it probably won't happen. I would probably agree with you on that. And to circle back to the poll earlier, if you had an offer for 35 years but were facing life, would you roll the dice on a trial? We're split 50-50 on that, so I'm going to break the tie. I would roll the dice. But I am solidly in my 50s, which means, you know, do I have 35 years left? Maybe, but maybe not. Probably not, according to statistics and averages. So I would most certainly roll the dice, especially if I was not guilty. But even if I was guilty, you might as well at that point, because for me, it would pretty much be a life sentence anyways. Texas continues to be where it's at. Let's go back to Judge Stevens.
Okay. Are you Kennedy Polidor?
Yes, sir.
I had 2 cases here, sir, in 25 CR 783. You were charged with the state jail felony of evading arrest or detention. Oh, you got more than just state jail, because you've got a conviction in two convictions in 2001 that may have enhanced this to a 3rd-degree felony. Then 25 CR 971, you're charged with a 2nd-degree felony of manufacturing or delivering a controlled substance, namely cocaine. This carries with it up to 20 years in prison. So you're looking at 30 years in prison here collectively. Serious. Ms. McNally is your attorney, and go ahead.
Judge, I have received an offer from Miss Gasper. I'm not sure of her updated last name at the moment, but I received an offer from her, but I've talked with Mike about a counter offer. There are some medical records involved that I have advised my client to get for me. If we could just have some time to get those medical records, that we could talk about the counter offer.
How much time?
3 or 4 weeks, Judge.
4 weeks.
Yes, Judge.
Also, he's not leaving until he gets tested.
Okay.
All right. We're going to need to test him for drugs.
Okay.
Make sure. Yeah.
Adrian's son.
You've asked for it. That's what happens when you charge with this type of offer. All right, Joey Childress. Polidor, we said 4 weeks in each of his cases. Who's Mr. Larry's? You want to file? I got one. I got one for you, Mike. There's an announcement. Okay, you or Joey Childress? Yes. You were charged here with this 3rd-degree felony of unlawful possession of a firearm by a felon. Second paragraph. goes on to allege you were convicted of felony injury to a child on March 23rd, 2012, which, if valid and true, would enhance this from a third to a second degree felony. But you were charged with unlawful possession of a firearm by a felon for injury to a child on March 23rd. But it's a different cause number. So you must have been convicted of two counts, two different charges of injuries to child.
Yeah,
Would that be okay? Okay, that makes sense. I now, okay, so they did this right.
Yeah,
Ammunition.
that were involved. And then
Okay, so it can be used, one can be used to turn this unlawful possession of a firearm by a previous convicted felon and use that previous convicted felony for the substantive crime of a third degree felony of unlawful possession of a firearm by a felon. The other conviction can be used to enhance, as it is done in paragraph 2, to enhance from a third to a second degree. Which is what happens under the law. So, announcement.
we're still in the process of going over the media.
It's March 19th. Okay, 4 weeks going to be good to make a decision, please.
Yes, sir.
Please get a resetting. Thank you. Stephen Dodd. Stephen Dodd is called in 24 CR 699. And the attorney is Michael Reisinger.
That's what she's got. They've been talking the two. He's here.
Oh, okay. Okay.
Distracted on the line.
So, yeah, could you call Stephen Dodd, please?
You
Thanks.
should talk to the attorney judge.
Okay, should I go out there?
He's trying to see if we can work it out. I'm gonna go get him.
Never too late to do such a thing.
Just.
Yeah. No way. Thank you. Maybe we get tea earlier when she showed it. He's in here.
Okay, we'll deal with him later. Jovan Saria or Soraya, John?
That is a play you're on.
I don't have it.
It should be coming through any second now.
I don't have it. Did y'all move it to
Did you
me?
sign it, Doug?
Soraya? How do you pronounce it? Saria?
Sarah.
Sarah? What is that that derivation from? Where,
I really don't.
don't know.
I'm going like that.
you don't, your family didn't tell you that. I mean, are y'all from, is anyone in the family from like another country or something?
We have.
I've never heard of that. Yeah. It's a great name.
Yeah, it's cool.
Okay, Sarah.
Yeah.
Whatever will be, is what that means, by the way.
Yeah.
I need to swear him in.
Oh, right here, the thing right there. She's gonna.
Ran people up to me. Right hand, swear or confirm. Here's what you got. You give your right thumbprint. Right there. You can check one more time. It's right there. Okay, so you kind of judge.
All right, 25 CR 1196 is called the State of Texas versus Jovan Sarah, which is you. Correct? You're here. Yes, you have to speak out so she
You gotta write it down.
Yeah.
Yes.
Okay. And you're here with John West.
Yes.
Your attorney and the state's attorney. Does the defendant waive a formal reading of the indictment and the arraignment here? Can we proceed in summary?
We can, Your Honor, yes.
In summary, sir, this indictment alleges, as you probably intimately know, that on or about July 20th of this year in Jefferson County, Texas, this states you committed the third degree felony of evading arrest or detention with a motor vehicle. Do you understand what you are charged with?
Yeah.
All right.
It's third degree. I've done the wrong paper.
No, you did a
I
state
did
jail.
the wrong paperwork. I just realized that. Yeah.
One word. It's gotta be a third degree.
It's gotta be the right paperwork, so let's just keep going down the docket and we redo the paperwork.
Okay.
Yeah, but
He's gonna have to redo the paperwork. He's got the wrong paperwork. Be redone. He filed a state jail felony.
I did the wrong paperwork. I didn't realize that. As you say that, I have to.
Just stay put, Mr. Sarah,
Just grab a seat back where you
Or
are.
you can just sit up here
Or right
close
here.
by so he can be,
It's just.
he can get right to
same
it.
stuff.
I don't know about you guys, but I hate when that happens when my attorney files the wrong paperwork. Okie dokie, let's get out of Texas for a few minutes. We'll go say hi to our friends in Louisiana.
Mr. Tillis to my left and Mr. Ledoux to my right. The panel today is at headquarters in Baton Rouge, Louisiana. Would the staff here please introduce yourself for the record? David Cavalier. Our remote location is David Wade Correctional Center. Would the staff at David Wade please introduce themselves for the record?
Brenda Ackland, Deputy Warden.
Taylor Sales classification.
Danny Henshaw, classification.
Sergeant Wyman.
That's all.
All right. And Mr. Woods, would you give us your full name and DOC number for the record?
Jeremy Lee Woods, 497135.
All right. I'm going to give you a brief explanation of the process. I'm going to read some information to the record, ask you to verify it. We're going to give you a chance to tell us what caused your incarceration and why you think you should be released. We're going to ask the warden to tell us a little bit about you. We're going to allow public supporters and public opposition if there's any. And we'll let you have the last say. So today we have for parole consideration Jeremy Wood, DOC 497135, who's a first felony offender who was convicted of forcible rape on September 23rd, 2005, and sentenced to serve 25 years hard labor in Bossier Parish. Your parole eligibility date is February 27th, 26. You're not eligible for good time, and you have a full term date of 11/28/29. Does that information sound correct to you, Mr. Woods?
Yes, sir.
All right. So tell us, what did you do to get yourself in jail? And why do you think now would be a good time for us to release you early?
2004, I committed a forcible rape. And I've been out getting high, and when I come home, I had lost control, and I mean, you know, I spun out of control and lost control and committed a horrible crime. Did you say you wanted to know why I should make parole?
Why would now be a good time for you to be released?
I wrote a statement, if that's okay, if I can read that.
That's fine.
I would like the opportunity to show all the people here at Wade that they didn't waste their time on me. Also would like to show society and all victims that rehabilitation is real, and show that I can be a productive member of society, and that people can change who they were and become the person they were meant to be. I've done the first 23 years of my life the wrong way, and for the last 21 years, I've worked on myself, learning how to be the best version of myself. And I would like to do whatever time I have left on earth doing it the right way. I allow drugs to control who I really am as a person, and it caused pain for everyone around me. I have worked and will continue to work on making sure I stay sober for the rest of my life. I don't feel like I deserve anything. I would just like an opportunity to show that I can do it the right way. Thank you.
Thank you. Warden, can you tell us a little bit about his behavior there? Any comments y'all might have, or problems y'all have?
Yes or no, he's not a problem inmate. He's never had a write-up here at Wade. He's been at Wade since, or anywhere. I don't believe you've ever had a write-up. He's been at Wade since February the 19th of 2007. He's gone through, received his high school equivalent diploma in 2007. Done a lot of trades, living in balance, victim awareness, sex offender phases 1 through 4. He is heavily involved in the special projects for community charities here at Wade, and he does a lot of that. He can elaborate on that, but he is not a problem inmate here at Wade. And y'all have any more questions? I can answer any questions.
All right. I don't have any questions of you at this point. Maybe later. All right. We do have some supporters here who would like to speak. We have Jeremy Woods Jr., a son who's at David Wade and would like to speak. We have David Woods, a brother who's in favor wants to speak, and that David Wade. And we have April Woods, a sister, who's in favor, and that David Wade would like to speak. So we'll start out with Jeremy Woods Jr. Would you tell us what you have to say?
You can just stand up right there and come up this way.
Just whatever.
Yeah, just speak.
First and foremost, I just want to say good morning and thank you for your time. My name is Jeremy Woods Jr. As you mentioned, I am the son of Jeremy Woods Sr. This is my father. Upon hearing a list of crimes and a list of past troubles that my father has lived in his life, and the things that he had done before he has come here, to me is almost incomprehensible, because it isn't the man that I've known, and it isn't the man that I've grown to know in my 21 years. I have had zero relationship with this man outside of the visitation walls that are to my left. I've never seen him outside of the walls, never had a conversation with him outside of this prison, and I don't know anything other than him being here. In those 21 years, I've never once been upset. I've never once blamed him. And I've never once felt sorry or upset about the situation. I believe that he is where he was supposed to be for the time that he was supposed to be here for a reason, and that God does not make mistakes. Excuse me. And that God that does not make mistakes. The lifestyle he was living was, it was a crash course. It was bound to end horribly. And if, some type of intervention didn't take place, to be honest, I don't think I'd have a father today. However, I can say that in his time here, there's been nothing but rehabilitation. The crimes and acts that have been spoken on so far this morning it's almost fictional to me. It sounds nothing like this man that I've grown to know through my life. It sounds nothing like the man that has taught me important values in life, such as honesty, perseverance, and overall just how to be a good person. I don't look at this man as a felon. I don't look at this man as a violent offender. I don't look at him as a threat to society. I'm not scared of him. I look at him and I see my dad. I see a man that came here whenever I was born and has served his time and has done all of the right things every right way. And he has done nothing but try and guide me and give me the best advice and the best type of father-son relationship he can from the parameters that have been set. I am a high school graduate. I am a soon-to-be college graduate from Louisiana Tech University in 9 months. I've accomplished a lot, but that's not really what this is about. It's about the fact that I was able to do that, and I was able to persevere without this man to my right. And it means a lot to me that he was able to support me and able to give me the strength and the motivation to keep going, because although he didn't reach those achievements and those heights in his life, he never shied away from telling me that it's not too late for you to do something. It's not too late for you to step up and be the man that you want to be. You don't have to let others dictate who you have to be. You don't have to let others lock you down and tell you that you're out of control. And I appreciate him for everything he has done for me, every lesson he has given me. And, this holiday season, I would love nothing more than to know that he's going to be home. I have a 22nd birthday coming up in March. I've never spent a birthday with him. I would love that. Like I said, I'm a soon-to-be college graduate from a 4-year university. I would love nothing more than to walk across that stage and receive my diploma and look out and see this man in the crowd. I don't have any sort of bitter feelings toward him. I don't blame him, and I have been nothing but excited, looking forward to this day for about the last 5 years or so. I don't believe that he is a threat to society in any way. I don't believe that there's anything for you to worry about. I have a home in which he's going to come stay if granted release. We would be living together. I believe that he deserves that. I believe that after 21 years of rehabilitation, of watching family members leave, of watching other family members accomplish things, the birth of his own grandchild, the marriage of his daughter, Me growing up, I mean, that's a lot to miss out on, and that's a lot of reflection and a lot of time gone. And I believe that if released, I believe that he's going to turn around and it'll be a complete 180 from the man that came in here 18 years ago. So I thank you for your time and your consideration, and I hope you have a blessed rest of your day. Thank you.
I got a question for you.
Yes, sir.
You say you're gonna give him a place to live if we were to grant him parole?
We already have home established. Yes, sir.
Have any of y'all looked into all the requirements that it's gonna be about the daycares, the schools, the parks, the playground? Somebody's home fits into that approved plan?
Could you repeat it one more time, sir? I'm sorry.
So for a sex offender to be released, he has to have an approved residence, which has to be, I can't quote the exact amount of feet and miles, but
It has to
this
fit
is
a
from a park,
criteria.
playground, a public school, a daycare. Are y'all aware of all of those things, and have any of y'all homes been checked out for that criteria?
They come and check.
We are aware of the criteria. We were told that somebody was going to come look at the residence and make sure that it did meet all requirements. But I don't believe anybody has came and did that inspection yet, but we are aware of the requirements and all of those things.
Anybody live in the country where no parks and playgrounds are around? Or daycares or anything like that, or y'all live in town?
No, sir, we're out in the country.
Okay, you got a better chance. All right. Next we have,
I would like to say, Mr. Woods, you should be very, very proud of your son. That is a fine young man.
Thank you.
all right, well, next we'll hear from Mr. David Woods' brother.
Well, I'm not as literate as my nephew, so I had to write mine down. If y'all let me read this. But touching on the house, I rented it. I made sure everything was appropriate and within range of everything, so everything's good to go. He has transportation, a job, working for me, so he's pretty well set up when he comes home. So, I'm David, Jeremy's older brother. Pretty much no one knows him as well as I do. I've known pretty much all the ups and downs from start till now. I respectfully, asking the board to grant Jeremy's parole. I understand the seriousness of his offense that has brought him before you and do not wish to minimize the impact of his actions. My intentions are simply to share my perspective on the man that he is today versus the man that he was when he came in, and the positive role that he can play if given the opportunity to return home. Basically, when Jeremy was young, he started out with the wrong crowds at the age of 12. He was basically, we lived in bad neighborhoods. He really didn't have much of a choice with who he hung out with. Jeremy started out with drugs at a very young age. As it progressed as he got older, I seen that it took a toll on his life running with the wrong people, with the drugs and all the stuff that he was getting into and the things he was doing. I tried helping him get away, start a new life in different places with me, and it just never could succeed with it. He just basically, I guess, if you run with the wrong crowd, you find the wrong crowd wherever you go sometimes. Jeremy made a lot of bad decisions growing up. Nothing changed as he was grown. I seen the days where he didn't even know where he was or who he was when he would come home, just from all the drugs and different things he was taking on a daily basis. I would like to say he was a victim of his circumstance and society as to where we grew up and lived, but I wasn't that way. So pretty much it was his choice to basically hang with these people, do the things that he done, and I chose to do differently. He was a good kid, had a good heart, just did a lot of bad things, a lot of bad places with the wrong people. And I remember that when he was arrested, and I thought there was no matter what the reason was for him being here, is probably the only thing that was going to save his life and give him a chance, at redemption and to live the life that he should live. Over the course of his incarceration, I've witnessed a significant change in my brother. He has taken responsibility for his past, shown genuine remorse, and made consistent efforts to better himself through programs he's completed, work he has done, the behavior I have seen and that he has shown. He has demonstrated that he is committed with personal growth and living a productive, law-abiding life when he comes home. The person he was is no longer the person he is today. I can pretty much guarantee that with 100% accuracy, because other than the tattoos he's got, he's a completely different human. And I've known a lot of people who's come in and out of prison. Most of them don't do that. Beyond his internal changes for the things he's worked on in his life so far, our family has seen how deeply he wants to repair his life and relationships with his family, gain everyone's trust to build a future based on stability and accountability. We have remained in close contact with him, and we have prepared to support him fully if he is granted parole. We have a stable company, and a vehicle, a stable house, and a vehicle that he can get where he needs to be when he needs to be there. He will be working for me as soon as he comes home. He is granted any time to take off to take care of classes, parole meetings, whatever he's required. He has that without worry of having to lose a job. We understand that re-entry is going to be challenging for him, and we are committed to helping him meet every requirement and maintain a positive progress that he has made. I truly believe that my brother is ready for a second chance. He has spent a long time reflecting, learning, and preparing for his better future. I have full of confidence he will honor the trust placed in him and work hard to contribute positively to his family and community. Thank you for hearing my side of my perspective, and I appreciate the difficult decisions that you must have to make. Thank you.
Thank you. We also have April Woods, defendant's sister here, who wants to speak in support.
Okay, I wrote mine down as well. Good morning, members of the board. My name is April Woods, and I'm the sister of Jeremy. Thank you for the opportunity to speak today. I'm here to express my full support for Jeremy's request to share request for parole and to share the changes I've witnessed in his life. Of course, I've known Jeremy his entire life. I have firsthand seen the transformation he's made during incarceration. I want to acknowledge the seriousness of the offense of which Jeremy was convicted. I understand the impact such a crime can have, and I do not take that lightly. My purpose today is not to excuse or diminish the harm caused. It is to speak to growth, responsibility, and genuine personal change I've seen in Jeremy over the years. He fully recognizes the weight of his past actions and that he has worked hard to become a better man than the one who entered prison. Jeremy now has a stable and well-structured plan for re-entry. He has a home prepared for him, as we've already spoken about, to live with his son. And it is not very far down the road from where my brother David lives, so he's very close to near dependable and accessible family support. He also has a job, as David has spoken about, to employ him upon release, which will help him reintegrate smoothly into the workforce. A new truck has been purchased for him, so he will have a reliable transportation for work and daily responsibilities, and the parole board's responsibilities as well. And I commit to personally supporting him emotionally, spiritually, and financially in any way that he needs as he transitions back into society. During his time in prison, Jeremy has demonstrated a remarkable commitment to self-improvement. As it's already been mentioned, he has earned his GED, showing dedication to bettering himself academically. He has developed significant artistic talent learning to paint and pursue creative work that gives him a positive outlet and structure. He's also earned a certification in horticulture and proved himself responsible and dependable by overseeing the greenhouse for a long period of time. These achievements show his willingness to grow, learn, and contribute. Jeremy has maintained excellent behavior throughout his entire incarceration, as you already have heard. This reflects his discipline, his respect for rules and authority, and the positive changes he has made. He has grown emotionally, mentally, spiritually, and physically. He's also dedicated himself to staying healthy through consistent exercise, which provides structure, purpose, and self-discipline. Spiritually, Jeremy has grown tremendously. He and I have had many sincere conversations about his life, his faith, and his commitment making better choices. Jeremy has turned to God for strength, guidance, and purpose, and his relationship with God has helped him make wiser decisions and manage his emotions in a healthy, grounded way. As his sister, I believe wholeheartedly in the man that Jeremy is today. He has a strong support system, a stable living situation, reliable transportation, and immediate employment waiting on him. He is matured, accountable, determined to build a positive future. I'm confident he will continue to make responsible decisions and contribute meaningfully to his family and the community around him. As a family, we are ready to hold him accountable, support him in following every condition set by the board, and help him stay on the right path and be there to support him every step of the way. We understand that parole is not a guarantee, but a responsibility, and we are committed to helping him succeed and comply fully as requested by the board. Thank you for taking the time to consider my statement. I respectfully ask for favorable consideration of Jeremy's parole today.
Thank you. All right, that concludes those we have in favor. We have nobody in opposition to speak today, but we do have opposition from law enforcement regarding her release. The victim and her family was unable to be contacted, so we have no victim opposition documented. My first question's already been answered. Where would you plan on living? And you got that taken control of. Just tell me, what's the most valuable class and the most valuable lesson that you learned while you've been in there for 21 years?
Victim awareness, I feel like was most valuable because it made me understand that my actions didn't only affect the people involved, but it affected everybody that was involved with that person. And I caused problems for everybody involved, mainly the victim, but the victim's family, the victim's friends, my family, their friends. Nobody won in the situation. The next class that I would like to say is the living in balance. It taught me about the triggers, how to be aware of triggers of drugs and anger problems, and how to recognize them and be able to control it before it happens. And the sex offender treatment program, the phases that, the risk factors they have in place, it allows you to be able to recognize any situation you may be in that may trigger you to cause you to commit another crime.
That's all the questions I had. Mr. Tillis, you have any questions?
How many kids do you have?
I have 2.
Where's your daughter? She
lives in Franklinton Parish. She lives down south. She can't drive. She couldn't drive all the way up here. She wrote a letter though, I believe.
Yes, sir. I have no more questions.
Yes, I do.
So were you ever married before?
Yep. Yes, ma'am. I was married to my son's mother.
Okay. But you were not, were you married at the time this happened?
We had just separated.
Okay. I have a question of your sister, April. Do you have children in your home, young children in your home?
I do. I have a daughter.
What is her age?
She's 15.
Do you have any concerns or plan to have any boundaries in place?
I don't have any concerns whatsoever.
That would automatically make her in a house, not have it.
Yeah, but I'm just concerned about visitation, things like that. I just want to make sure that you have some boundaries in place. Should he be released, you need to have some boundaries in place for supervised time only.
Oh, I will always be there. Supervised at all times.
Yeah.
If he's ever, I live in Dallas.
Oh, you live in Dallas?
Yes.
Oh, okay. Thank you. I don't have any other questions.
All right. I move for executive session.
Second that.
So, Danny Barrow,
Yes.
Chucky Tillis,
Yes.
Geraldine New.
We're gonna discuss some confidential information. We'll be back.
That's fine.
Okay, well, they go to executive session. Let's us go back to Judge Stevens for a few minutes.
We've put in the request and,
You're Stephen Doc? Yes, okay.
Yeah, we're working on getting those pictures right now, so hopefully we can resolve this thing.
What do you mean, pictures? I don't even know. I don't.
It's a criminal mischief. There's a alleged incident where there was damage done to.
Can that get done pretty quick? Because it's over a year and a half old, 18 months. It was indicted in April of 24. That's old for me, for us, so.
Well, it hasn't been a year yet. I'm just saying.
No.
For y'all.
April of 24 is over a year and a half old. April of 24. It's December of 25.
I was thinking April 25.
That's okay. Okay. That's
Your Honor, what? No, I was just saying, I just need a little more time to maybe, I think we're working that.
By the way, have you done your Christmas shopping? It's Christmas is coming up.
I have not.
Oh, I know you're wrapped up in all that work, but yes, December.
Yes,
we're in December.
Yeah.
Families remember that. Forever. If you don't, yeah. All right.
There's a lot of things I need to work on. That's one of them.
Yeah, welcome to this room. Because yeah, we ought to be that. There are a sign outside that says needs work. But we're working as hard as we can.
I agree.
All right. So can this get done in 4 weeks?
We're hoping we can resolve this thing.
That's a yes. Okay. I take that as a yes. I'm a positive kind of guy. What do you think?
I think
I'm going to listen to you because Mike's.
Well, I mean,
Mike's making up stuff as he goes. I can tell.
I think if we could get the Christmas spirit in the DA's office,
you can ignore Christmas.
Well, maybe New Year's spirit then, I guess. I'm gonna get those pictures for you today.
Yeah, sure.
Yeah.
That's what I'm I'm understanding. Right?
And you're going to get gifts for the whole family before Christmas, or
I don't know about that.
Right.
That's a little much to ask for, Judge.
All right. Get a resetting 4 weeks, sir.
Thank you.
Jacorin White.
7.
That's fine.
What are we going to do on Jacorin?
Your Honor, we get some more time on that one. We need to go over.
Oh, yeah.
Okay, let's go back to Louisiana and get their final answer.
Well, she's gonna be all day.
We have to make a motion to come out of
I
executive
move
session.
that we get back into executive session.
Second. Second.
All right, we are back into the regular session and ready to vote. I'm the guy who votes first, since the case was assigned to me, and looking at the amount of family support that you have, the good programs that you've done. I'm gonna vote to grant you parole today with the condition that you have an approved residence plan before your release, and that you abide by curfew from 8 p.m. to 6 a.m. except for work until the probation and parole officer determines that it's not needed. That you register and notify the regular sex offender requirements, and that you do a mental health evaluation and follow any recommendations that they make. If they make none, well, then you don't have to do anything. and that you have absolutely no contact with the victim or her family. That's my vote. You need a unanimous vote. Ms. Ledoux?
Mr. Woods, under current law, an offender must serve 85% of their sentence before release, and you were at that 85% at your parole eligibility date. My vote is to grant parole today. The advantage to doing that is that you're going to have supervision, and I think that that's a better situation than waiting till your full term date and you have no supervision. And so my vote is to also request that you have no contact with the victim, and you need to have supervised contact with children under the age 17 and under. I just think that that's going to be an appropriate requirement. I would like to say again that you are very fortunate to have the family support that you do, and we see many failures because of lack of family support. And so I just wish you well. And my grant does not diminish the crime you've committed. Okay.
Mr. Tillis?
Mr. Woods, you've done something that was horrible. And I really I guess because of your family support and I hope that you will do well and not have this problem again and abide by the rules and regulations. So my vote today is going to be to also grant.
All right, Mr. Woods, you got all three of us. So
Thank you.
what that means is your parole has been granted with a bunch of conditions. And this would conclude our business with you today.
Thank you.
Okay, whether you agree or disagree with what just happened, there was an interesting thing that came up that we've not seen before. And that was when Ms. Ledoux said the advantage of paroling him now was that they could keep him under supervision, where if they let him do the remaining 15% of his sentence, that after that he would walk without supervision. That's an interesting point, and not one that we've heard before out of this board. So that makes it a little bit different for me. It makes it interesting because you're putting him out on a leash now as opposed to just letting him run free in a few years. Is there an advantage to that? Yeah, there might be. This might have actually made more sense to do, regardless of how you feel about the crime and everything else. This might have actually made more sense to do. I don't know. Debate it in the chat. Obviously, these are cases that we all get passionate about, but that was an interesting thing, and I think it's worth talking about. This might even need to be a sidebar discussion at some point. I don't know, but think about it. Anywho, back to Judge Stevens.
Okay. Mr. Sarah? 25 CR 1196 is called. Does the defendant, who's here with his attorney, waive a formal reading of the indictment and arraignment? Can we proceed in summary here?
Yes, Your Honor.
Get out of this state jail felony and get to the correct paperwork.
Yes.
Ken is working the door today really hard.
Yeah. On this one. This turn that is a good job.
He does great.
Definitely just takes.
Been lucky. I've had great. Yeah, okay, we're okay. Great folks taking care of us. As officials. In this 25 CR 1196, Mr. Surratt present with Mr. West, your attorney. In summary, this indictment alleges that on July 20th, 2025 in Jefferson County, Texas, you committed the third-degree felony of arrest or detention with a motor vehicle. Do you understand what you were charged with?
Yeah.
If convicted, you face a term of not more than 10 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand the punishment range applicable? It's serious.
Yes, sir.
An agreement's been reached where you would be pleading guilty and not found guilty, placed on deferred or unadjudicated probation so long as you follow terms and conditions of probation, which are normal and customary for this type of offense. Is that your understanding of the agreement? Now, also, probation can be up to 10 years in length. I see they're going to try to talk me into 5 years.
Right.
But it's my call. Whatever it is, if you do well, will you do well? Yes, it will be shortened to 1/3. To 1/3 of that, whatever it is. If I follow this agreement, you have no right of appeal. Do you understand?
Yes, sir.
How do you plead to this, sir? Guilty or not guilty?
Guilty.
Yep, speak.
Guilty.
Are you pleading guilty voluntarily on your own free will and because you are guilty?
Yes, sir.
Show you what's marked. You know, touched it and made marks.
Can't wait to get the new ones.
Good luck. Supposed to be here by Christmas.
Well,
2028.
probably, yeah.
I'm going to show you what's marked as State's Exhibit 1. Did you sign that document voluntarily? Understand it? Discuss it with your attorney? Are the contents all true and correct?
Okay.
State's Exhibit 1 tendered into evidence.
No objection.
Without objection admitted. Among other things, this states you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it.
Yes,
You're
sir.
guilty of the crime charged and any lesser included offenses. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. Totally satisfied with the representation provided by your lawyer. All true, so help you God. Correct.
Okay.
State's Exhibit 1 made a part of the record for all purposes. Pre-sentence reports waived.
Yes, please.
I'm going to follow this agreement. I'm going to find you have pleaded guilty. If nothing further, you have pleaded guilty voluntarily. You are mentally competent to do so. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt. But I'm not going to do that so long as you follow these terms and conditions of probation, which include, among other things, don't commit crimes, the kind of things we all are required to do for the most part. But you must complete a defensive driving course. That's a win-win for you. It'll make you a better driver. Also, your insurance rates will go down for that. And you do have to have insurance, you know, when you operate a motor vehicle. There will be other terms and conditions of probation, which are normal and customary. Now, this says 5 years that's been written in here, and the court defaults generally to 10 years. What do y'all say? State?
I agree with the 5-year
It's
request,
done.
Judge.
It'll be, your probation will be 5 years. So you do well, shorten it to 1/3, 1 2/3 years.
Yes, sir.
Can you do it?
Yes.
Good, good. I'm going to ask you to see the probation officer and you will begin probation. Good luck. Thank you. All right, on Mr. Polidor, he failed not.
Don't do that to me, Judge.
He did well. He did well. He's clear, good. And what are we going to do?
He has his
Let's reward him.
He has his reset, Judge.
Okay, till when?
It was 4 weeks.
Okay, then what are we going to do?
I'm going to be speaking with Miss Gasper about a counter offer, and then my client is also working on getting medical records.
Okay. All right, anything else? Please get resetting. Merry Christmas and do well. Follow her advice. Okay, you got it resetting. Thank you. And
all right, let's step across the hallway to Judge West again.
Kashma Thomas and Mr. Rojas, will your client waive the formal reading of the motion?
He will, Your Honor. Judge, with the court's permission, we're going to abandon 5, 6, and 7. It's my understanding that those cases have been dismissed.
Okay, thank you, Ms. Malfino. Mr. Thomas, in clause number 23, DCCR 3.5, I have a motion to revoke your community supervision. It shows that you were placed on probation October 17th of 2023 for the offense of evading arrest or detention with a previous conviction. That was a 2-year state jail felony term that was probated for 5 years. Is that correct? And wait, was there a first amended? Hold on. What am I? Oh, sorry. I'm looking at the wrong one. First amended. Here we go. Give me a second. I know, I feel like it's cold in here. We're all sniffling. Okay. It's a first amended motion to revoke the community supervision. It alleges in count 1 that you violated your probation by failing to report to the probation office as directed May 22nd, June 26th, July 17th of 2024. And is that true or not true?
True.
Count 2 alleges that you provided a urine sample March 18th of 2024 that tested positive for tetrahydrocannabinol. And is that true or not true?
True.
Count 3 alleges that you failed to pay your court-assessed fees as directed, and as of July 17th, 2024, you were behind $820. Is that true or not true?
True.
Count 4 alleges that you were arrested for the offense of evading arrest or detention with a vehicle February 5th of 2025 in County, Houston. Is it Harris County?
It's Houston.
Is it Houston County? Okay, so not Harris, it's Houston County. Is that true or not true?
True.
And then the state abandons 5, 6, and 7. Count 8 alleges that you failed to remain in Jefferson County as directed and that you were in Houston County February 5th of 2025 without permission. Is that true or not true?
True.
And then count 9 alleges that you possessed a drug, marijuana, on February 5th of 2025 in Houston County, Texas. Is that true or not true? Did you enter your pleas of true to counts 1, 2, 3, 4, 8, and 9 freely and voluntarily?
Yes, ma'am.
And did you plead true to those counts because they're actually true?
Yes, ma'am.
I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Rojas?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
State tenders number 1.
No objections.
It's admitted. Is there any evidence that Mr. Thomas is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of true to counts 1, 2, 3, 4, 8, and 9 freely and voluntarily. Find those counts true. Find sufficient evidence to revoke your probation, and at this time, revoke your probation. Reassess your punishment in accordance with your agreement to a term of 15 months in the state jail prison. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I have handed you the trial court certification that shows this was an agreement that I followed, so you have waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. I went over that with you when you entered your plea at the first hearing because you were convicted, but I do want to make sure you read it and understand that because you are convicted of that offense, you're not eligible to possess a firearm in Texas, okay? All right, you're free to go. Back with the bailiff. Thank you, sir.
Okay, friends, a couple of minutes early for ending it, but I just took a look at the other feeds that I'm monitoring, and there's really nothing else that makes sense to go to finish off the day, so we'll just call it right here. We'll be back tonight, 8 p.m. Eastern, 5 p.m. Pacific for Sidebar. We haven't done Sidebar in a couple of weeks, so be sure to check that out. And, of course, we'll be back tomorrow, 10 a.m. Eastern, 7 a.m. Pacific for this lovely morning show. This was fun. Let's do this again tomorrow. In the meantime, go have yourselves a great day. I hope we can see you all tonight, but take care. God bless.